Okay. It has not been reached for 2 occasions. Lordship has called for
Item numbers.
item number Lordship 40, 41, 42. Analogous matter. At 2 Lordship.
Matters about what?
Regarding selection and appointment of principal.
Other side.
Other side, the government and the private party will inform.
Inform them.
Will inform them.
No, you inform them first. You will accommodate.
BTC is the main party. BTC is main.
Otherwise,
BTC was directed to produce some records.
you are for with Mr. Nayak.
No, Lordship, Mr. B. Chaudhary.
Okay.
He said to take it. The meeting came up Thursday.
We'll have it on Thursday. It will be a hearing day.
This is the usual practice.
No, it's not the usual practice.
BTC.
At times, you might also have a problem. That's Thursday.
I should not tell. Okay, this is going on.
Okay, we'll stop it if it's going on. Thursday we'll have it. The bark will stop on Thursday. Will not pass anymore.
Record.
One second. Item numbers?
40, 41, 42.
Hello.
40,
41, 42.
40, 41, 42.
A prayer for adjournment has been made on behalf of the BTC. On the other hand, Sri Goswami, the learned counsel for the petitioner, expresses the urgency in the matter. In view of the above, place this case for admission on Thursday.
May I please allow?
But Thursday you need to come early, Mr. Goswami. Thursday you need to come early.
Okay.
You know why?
Okay.
This court may not come early, but
May I please allow?
yes.
Recommendation item number 17 in your lawsuit.
17. Yes.
The petitioner has already got relief your lawsuit. I want to withdraw this.
How many prayers for withdrawal today?
Now,
All cases cannot be withdrawn. You should follow your Mr. Muzumdar. Yes, you are also withdrawing. You should follow good principle. Sri R. Muzumdar Learned Counsel for the petitioner submits that during the tendency of the writ petition, the grievance of the petitioner has been redressed. The para also heard elementary
element.
for the state, Sri Bokolial for Learned State Council, Sri P. Bora, Learned Standing Council, Elementary Education Department, and 9, anyone?
Yes, Mr. A. Kayum.
Is there in the court?
I will inform you. A. Kayum.
No, is it there in the court? We want to record the presence of the council. If he is not there, we will not record.
He is present in the bar.
And Sri D. A. Kayum, Learned Counsel for the counsel for respondent numbers 7 to 9. Repression accordingly stands dismissed on a trial.
May I please allow?
No interim order.
May I please allow?
Yes.
I threat for listing admission matter on Friday morning.
Why did this week, whole week, admission we are full next week, next Monday?
Monday.
Lordship, I beg to mention for listing. Lordship can remember the written application for step vacating. It was posted on 26th. On that day, because of typological error, Lordship contacted me liberty to withdraw and file it. So I have already filed. It may come up on Friday, Lordship.
That matter where you have written the numbers
Yes, I have correctly written.
corrected?
Yes.
New application file?
Yes.
Okay, right.
Listing my lord on 5th or 7th.
5th?
Or 7th.
Next Monday.
Next Monday or next Wednesday.
Whenever.
May I please allow? Lordship, I pray for listing, my lord. Why I am making the submission, my lord?
When?
My lord, tomorrow or day after tomorrow. My lord, why I am saying so much?
Motion or what?
Hello?
Motion matter.
No, my lord. My lord,
No need to take submission.
my lord, this honorable court has passed an order not to finalize the post, my lord. But we have communicated. But my lord, the respondent authority has, my lord, selected the candidates, my lord. And they have been directed to join honor before 1st to 15th.
So have you filed any IA?
My lord, I have filed an affidavit, my lord.
Affidavit will not do. File an IA, we will consider. If that is the situation, you have to file an IA, you have to have a prayer. If something has not been followed or complied with, you come before us. Inform us by means of an I will pass appropriate orders. Friday, tomorrow we'll have it on Friday, if that is the situation.
Obliged, my lordship. Stay vacating petition may be posted on Friday, my lord, because I last listed on 19/10/20.
Day vacating.
My-
Case of which year?
Of 22. Obliged.
It is a lot. I beg to mention a 2017 contempt matter,
Contempt, 17,
2017. The petitioners are at the fag end of the life.
their life. Their life.
Not exactly that, your lordship. They've aged, they've gained years, your lordship, since the order was passed. A very categorical order. In fact, for the past 6 years.
When do you want?
I'll leave it to your lordship.
Next Monday.
Next Monday. I'm grateful, your lordship.
Ma'am, I want to back to mention item number 66 lottery.
66, yes.
Thing for upgrade lottery, back to lottery, possible lottery, the content matter, first time lottery.
Contempt, why should we upgrade a contempt matter? Tell us.
Previous two occasions, the problem
No.
released the lottery.
This is not an exceptional case.
It's record only the 5 second or 10 second lottery, first time lottery.
It's not a question of seconds. Why should we upgrade a matter
But
unless you make it an exceptional circumstance? All matters are important for the council. No, sorry. Sorry, yes, next.
Yes, may I please your lordship, I beg to mention for listing
Alright.
for the motion.
Motion, when?
On the, on 31st May, on the last occasion dated 12, Honorable Court passed for only 1 week to be listed the matter, but. has
It is
not been
still at the
listed.
stage of the motion.
Yes,
Okay, 31st. Day after tomorrow.
not surprised.
May I please, your lordship? My lord, may I pray for listing this motion matter, my lord? It was, my lord, filed on 15/3/2000.
When do you want motion?
I have given here date day after tomorrow.
May it please your lordship. Item 55, it should come for motion, my lord. but-
We'll have it as motion after the motions are over.
Yes, my lord, highly obliged.
I believe. So I bring for listing of a case on Wednesday.
This
Edition.
Wednesday.
Yes.
No, this Wednesday is not.
Late cover matters, lordship.
This Wednesday is not possible. Next week.
Lordship, within week, lordship, any date, lordship. have one-
Wednesdays and Fridays, we have already fixed many cases. It's not possible.
This
Next
month.
Monday. Next Monday. Yes.
Maybe the lordship. I back to mention on listing contempt is the lordship for order.
Why? What is matter of which year?
Matter related to
Which year?
2020.
We'll have it next week, next Wednesday.
May I please your lordship? Lordship, I beg to mention item number 56. Lordship, matter has been wrongly listed for orders, lordship. Matter should be taken up as a motion matter, lordship.
56.
56, lordship.
We'll check and we'll have it immediately after the motion.
Obliged, lordship.
May I please, lord. Therefore, listing lordship for order lordship. A content matter lordship. Last posting lordship 9/11/2021 lordship. This
Next
application
week, next
Friday
Wednesday.
lordship. Friday.
This Friday? No, not possible. Next Wednesday.
Date, lordship. Date.
Yes, sir, next Wednesday. Put next Wednesday.
May it please your lordship. Lordship, I beg to mention item number 65.
65, yes.
Lordship may be pleased to take up the matter. Many occasion matter has not been listed.
Hmm.
Matter relating to family pension, lordship, petitioner has.
If it reaches, we'll take up. Why not?
Lordship, because.
Earlier occasion, this bench was not taking up this, this court was not taking up this bench. We'll see if we may reach. Yes, next.
May it please your lordship. Lordship, I beg to mention item number 54. Lordship, it came under the orders column. If your lordship pleases, let it be taken up in the end of the motion list.
This is the motion matter.
Yes, your lordship.
54.
54.
I think all 54, 55.
Yes, your lordship.
Okay, we'll have it immediately after the motion.
Much obliged.
But why the 54 is fixed? Why?
Lordship, last occasion also it came up and due to paucity of time it could not be taken.
At the stage of motion. Take it up, motion. Just remind our court master.
Item 65 maybe before rising, if not listed.
We will not grant any.
Petitioner at the part of extermination, lordship.
With the council, we cannot grant any privilege. All matters are important. If it reaches, yes, why not?
May I please, your lord?
Yes.
My lord, in this case, my lord, the resolution for making the managing committee of the school is challenged. My lord. On 3/3/2022, my lord, there is a direction to file affidavit with the respondent.
Lordship, on the last occasion on 17/11, my lord, an order was passed to lordship, but that order was due to some technical thing, my
Okay,
lord. We got
okay,
it last
we'll grant some time.
sometime.
These matters we are taking in an exceptional way. Some due to some technical snag, the matters were not copies were not available. You also know how much time? 3 weeks.
Well, 3 weeks. And also, my lord, in September, my lord, this thing will get over. period.
We'll fix a date also. Okay.
2 weeks may be granted in the matter may be.
Uh,
TV.
3A Fukan, Learned Standing Council, Elementary Education Department, submit that though there was a direction for production of the record via an order dated 17/11/2022, comma, due to some technical issue, comma, the copy of the order was could be could be obtained only recently. He accordingly prays for and is granted further 3 weeks time to do the needful in terms of the state order dated 17/11/2022. Para, list on, give us a date. 3 weeks. We'll have it on 21st of June.
My lord,
Yes, next.
deeply blessed. May I please? Well, a matter related to instance headmaster of a MA school, my lord. In this case, my lord, petitioner before lordship is the senior teacher of the school. Accordingly, he was allowed to hold a charge of instance headmaster in 2020, my lord. Thereafter, accordingly, he was continuing.
You filed your affidavit, Mr. Goswami, you are for whom?
In fact, my lord, here I am for a private respondent,
Advance for
And-
a department.
and department has already filed affidavit. We received the copy of the affidavit.
Okay. You filed a rejoinder.
I will file his end, my lord.
You have filed.
File, my lord.
Okay. Then you have already filed your pleading.
My lord.
We have not got a copy of the reply.
Rejoinder copy you have not given.
Then I will give you.
Give a copy, then we can have it this for admission. Next Tuesday. Not tomorrow, next Tuesday. Okay. You can dispose this of 22 matters. What is the issue involved?
Regarding in charge headmaster of the post.
Okay. Yes, yes. Presently, who's in charge? Your client.
In
No,
view of
petitioner,
the interim order, the
I am-
petitioner has been continued.
I am like continuing, my lord.
Okay. It appears that pleadings have been exchanged in the meantime. However, the Fukan, the Learned Standing Council, Elementary Education Department submit that copy of the return has not been served upon the department. Para,
My lord, 2 days till I have.
3, para 3, B. Rahman, the Learned Council for the petition, has served a copy to Sri Fukan in the court. Also heard the U. Goswami, Learned Council for the private respondent. Number 5, UK Para, as agreed to by the parties from a list for admission on say, 1 second.
Can it be on 8th, my lord?
But was formal notice issued or not?
My lord,
Issued, my
When? Which order?
lord, 6/4.
4. Yes, you're correct. Is anything?
Can
Which
it be on 8th?
8? Monday, next Monday.
Thursday, my lord. Next month, then no
Okay,
problem. But on Tuesday, my lord, I have some.
Okay, we'll have it on 8. On 8?
13 my lord.
8.
Yes,
8 June.
in the order.
Interim order passed earlier. To continue to the next date only.
Matter pertains to provincialization. I have been dropped from provincialization as per 2017 Act. Otherwise, I am eligible for the.
Who they pay for secondary
I am
department?
appearing, my lord.
In this matter, we have received an instruction, my lord, and as per our instruction, in the year of 2016,
Here in Gogamud Senior Secondary School.
You'd like to
have
file an
156?
affidavit?
No.
Mr.
Yes,
Sharma?
we want to file affidavit.
Mr. Neuk, let them file the affidavit. Notice issued or not?
Not recorded.
Oh, no.
Pursuant to the order dated 30/11/2022, comma, instructions have been obtained by the Learned Training Council, comma, a secondary education department. Full stop. Sri Sharma, U. Sharma.
Yes.
The Learned Training Council, however, points out that formal notice is yet to be issued. Full stop. Para. Issue notice returnable by 4 weeks. Sri Sharma, the Learned Training Council, Secondary Education Department, accepts notice on behalf of respondent numbers 1, 2, 3, 1 to 3, I think. School Management Committee,
School management point.
can you accept?
No.
1, 2, 3. District Scrutiny Committee, Sri Bokalial, the Learned State Council accepts notice on behalf of respondent number 5. Extra copies were served upon you, I think, earlier. Let extra copies of the writ petition be served upon the Learned Council, if not already served. That steps be taken for service of notice upon the respondent number 4 by registered post with 80 steps by tomorrow. By the returnable date, comma, the department is required to file the affidavit based on the instructions said to have been received.
Understood.
May I please, Your Lord?
Yes.
My lord, the case was only, what is the last examination? As far as the 2017 Act and 3(7) is considered. My lord, in paragraph 17 and 80.
Your
of the last
instructions
order-
received?
Instruction has not received here, ma'am.
Get the instruction. Notice was issued, I think.
Notice was issued and it was, my lord, already finding is there. It should be the examination of.
You get the instructions.
Yes.
We left this for admission. How it should be Aberdeen Learned Council for the petition. Para. This court by the order dated 10/2/2023, after recording the submissions and the provisions of law, had issued notice. Full stop. Sri Sharma, the Learned Training Council, however, submits that instructions are yet to be received. Full stop. Para. On the prayer of the department, comma, matters can be done by 3 weeks. 3 weeks to enable obtaining of instructions.
Could you have a date, my lord?
Tell us. 3 weeks. 1, 2, 3. We'll have it on 21st.
No, my lord, 26th.
26. Okay,
Yes, sir.
26 June.
My lord, 28 or 30, my lord.
28th of June. 28.
No, 28th will be something. 29th is Eid, my lord.
30, my lord.
Then 23rd. 23rd June.
My lord, only thing I'll be out of station because of a medical urgency. So on 26th,
Medical urgency, how do you know now?
already tickets are.
That is not an urgency, that's something planned. Urgency is something which is unexpected.
Yes, my lord, but that was unexpected. Within 1 month has to be done. That is the thing.
That you have planned?
Yes, already planned.
That is okay.
My
That's
lord,
not
26th, let us see what happens.
26. Okay, 26. Item 5. That's all. What is it?
My lord,
Instructions obtained.
Yes.
What is there? Mr. Ahmed, you are for the AG.
Yes, sir.
Determined on account of mismatches and rate. Yes, yes. Treasury office.
But I appear for the SSA.
I think it can be sorted out.
Yes, sir.
Have you seen the instructions, Mr. Gogoi?
No. Okay.
They say that there was some mismatch of dates and rates, so it was returned. And now it has to come back from you.
Lordship.
You take instructions?
Yes, I will manage.
Mr. Chauhan, let it remain in this stage.
Yes.
We'll ask Mr. Gogoi to have the instructions.
Lordship.
And we'll ask Mr. Ahmed to give a copy of this to.
Lordship.
The Learned Standing Council, Accountant General, has submitted before this court, has placed before this court a copy of the written instructions dated 26/5/2023, from which it appears that though the pension proposal of the petitioner was submitted to the office by the department, some mismatch of dates and rates of family pension was noticed, and the matter was accordingly remitted sent back to the concerned treasury officer to rectify this table. Sarah? Sri Gogoi, the Learned Standing Council, me Gogoi, Learned Standing Council, Finance Department is accordingly directed to have the instructions and status of the rectification process put up. Sarah? To facilitate Sri Gogoi to do the needful, let a copy of the instructions along with the relevant documents be served upon him.
One line, Lordship, Mayor, my lord, if required, I can have the instruction from the treasury officer also, though he is not a party. I will do that.
Treasury officer.
That may be indicated.
Sarah, it is clarified that though the treasury officer, which treasury? Mongoldo is not a party respondent, Dorong is not a party respondent, Sri Gogoi may obtain instructions, necessary instructions from the state officer also.
Right.
We keep this. Do you have an extra copy of this?
Yes.
We keep this with the record. Copy of the written instructions is kept with the record.
Can it be after 10 days?
List after, we give you 2 weeks. List after 2 weeks. Will not we give a date? Pension matter. A list on 14th of June.
My lord, is related to the compensation department. Last occasion, lordship, my learned friend was asked to verify the judgment of coordinate bench lordship about verify whether this judgment is applicable to my case. And lordship, some record I need to challenge also. So at this stage, I pray, let the matter, I may be allowed to do the liberty to file a press.
Okay.
Because by annexing some documents.
Sri K. Muzumdar, Learned Counsel for the petitioner submits that due to some subsequent development comma, he has been instructed to withdraw this petition, however, with a liberty to approach afresh by making by amending his prayer. Also heard three. P. Saikya, the Learned Standing Council, Secondary Education Department, who does not Learned G, who does not object to the state. Who's for secondary? I am for. And P. Saikya, Learned G, and Sri U. Sharma, Learned Standing Council, Secondary Education Department, who do not object to the same. Petition accordingly stands dismissed on a trial with liberty has paid for. Mr. Goswami, which matter is yours? If you want, we can grant you some privilege. Which item? Item number? 11. Oh, 11 will reach.
May I please the Lord, my Lord. My Lord,
Yes.
matter pertains to compassionate appointment, my Lord. The case of the petitioner was placed on various occasions before the district level committee, my Lord. But because that could not be considered because of, my Lord, want of vacancy, my Lord. And the, my Lord, clause 15 of the office memorandum, my Lord, dated 1/6/2015, it says that, my Lord, when the vacancy is not available in the concerned department, a fresh consideration is necessary in
Yes,
the
yes.
department.
Lord, I have the instruction, my lord, during that period, my lord, the clause 15 was not considered because there was no vacancy, my lord. So the question doesn't arise. Otherwise, so it was placed in various occasions.
See, one-time consideration on merits is required.
Yes.
Lack of vacancy is not a consideration on merits. And the OM says that if there are vacancies in other departments, you can also consider in those departments.
My lord.
Have you made those that consideration?
At that point of time, there was no vacancy in any other department.
Any other department? You make the consideration
Yes, my Lord.
whenever vacancy arises.
Lord, will kindly dispose of him. I have a decision of this normal court, my Lord. Very recent decision. My Lord.
Decision is not required for this kind of matter. Or Sri Jed Hamad, Learned Council, for the petitioner. Also heard Sri. You appear from whom?
Lord, I appear for respondent number 4, my lord, deputy group. DLC.
To Learned the State Council for the state respondents. Considering the subject matter in dispute and as agreed to by the parties, comma, represent is it in the motion stage?
It was taken in motion statement.
Considering the subject matter in dispute and also and as agreed to by the parties, comma, this matter is taken up for disposal at the motion stage. It may be mentioned that why that pursuant to an order dated 11/5/2023 of this court, comma, the Learned State Council has obtained the instruction. The projected case of the petitioner is that his father, what was the name of your father?
Father is, my Lord, late Idris Ali.
Idris Ali was working as what?
Head teacher, my Lord. Mehari par Ami Madrasa.
Was the head master of Meherpar Ami Madrasa in the district of Nagaon. Also, he, however, expired on 6/9/2015 while in service, and the petitioner, who claims to be eligible for consideration for appointment on compassionate ground, had made an application on 16/3/2016 Full stop. However, comma, the petitioner's case has been rejected with the remark want of vacancy. Full stop. Sarah? The learned counsel for the petitioner has relied upon the provisions of the office memorandum dated 1st of June 2015, more particularly clause 15 thereof, which reads as follows. As per the said provision, comma, a procedure has been adopted giving liberty to the administrative department public office to take up the matter with other departments to provide an early appointment on compassionate ground. Full stop. The learned counsel for the petitioner submits that the aforesaid provision was not applied and the rejection has been done in a mechanical manner. On the other hand, comma, to the learned state counsel submits that the projection made by the petitioner with regard to the consideration part is not correct and the rejection was done as vacancies were not available not only in the concerned department but also other departments at that point of time.
My lord.
The learned state counsel, however, is not opposed to the principle of law that one-time consideration on merit is mandated in a case for consideration of appointment on compassionate ground. In view of the above, comma, this petition is disposed of by remanding the matter to the district level committee, comma, Nagaon, for a fresh consideration on merits in the next meeting and consider the case of the petitioner in accordance with law. Petition accordingly can dispose of.
Highly obliged.
15 to 40.
Petitioner is a gift by non-provincial this my lord. Not last.
Non-provincialization.
On last.
Yes, instructions.
My lord, I have received the instruction. My lord, here, my lord, DLC has recommended the name of the petitioner, but unfortunately.
Not DLC, the scrutiny committee.
District scrutiny committee.
Mm.
But unfortunately, my lord, state level scrutiny committee has not oversight the name of the petitioner. He is eligible to, my lord, recommend.
It is an upper primary school.
Yes, my
3 teachers.
lord.
Your discipline is what?
Language.
Language,
Language.
my lord.
And who are the other 2 teachers? In which
My
discipline?
lord, the three teachers has been, my lord, the provincialized. As per my lord enrollment, there are 125 students, my lord. As per section 25 of my lord, to relax, my lord, school having enrollment more than
No, if
100,
in the case you are considered for provincialization,
my lord,
one person who has been made a party, Raspan was 6.
my lord. My
His
lord,
provincialization will be affected.
my lord.
I think the notice of motion
My lord, my lord, my lord.
without giving him a chance,
My
we
lord.
cannot.
My lord, that's one number 6 was recommended as headmaster, my lord, as per my lord enrollment. So his service has been provincialized as headmaster, my lord.
No, ultimately there will be 3 teachers whose services will be provincialized.
My lord, if the enrollment is more than 100, my lord, as per section, my lord, 25 of my lord, the
Yes.
right of children.
That will come only after merger of the
My
school.
lord, if annulment is more than.
Well, issue notice at this stage. Notice is issued or not?
No, my lord.
That notice is issued. There is a private respondent. It not be fair to dispose of a petition of this nature.
He's the headmaster, my lord.
Yes. Your J. Islam, heard J. Islam learned counsel for the petitioner who is aggrieved by the action of the respondents in depriving him from the benefit of provincialization of his services, which he is rendering as a teacher of Abrar Pitha M.E. Madrasa in the district of Gwalpara.
My lord.
It is the case of the petitioner that under the Assam Education Act of 2017, comma, an exercise was conducted for selecting the schools for provincialization of the services of the teachers, in which, comma, the district scrutiny committee had recommended the name of the petitioner, which, however, was overlooked by the state scrutiny committee, state level scrutiny committee. Para issue notice returnable by 4 weeks. E. Bora, the learned standing council, elementary education department,
1, 2,
accept notice on response numbers 1,
2, 4 and 5.
2,
4 and 5.
4, and 5, whereas government peace IKEA and state council accept notice on behalf of response number 3, that extra copies of the writ petition be served upon the learned council for the parties by tomorrow. Sarah, that shall be taken for service of notice upon the response number 6 by registered post PKD. Service by tomorrow. Yes,
Blessed.
yes, what is this?
It is also. This matter pertains to the condonation of the age of the petitioner to appear in the interview conducted by the APSC. Lordship, on last occasion, Lordship, direction was given to the elementary department to take instruction, Lordship, regard to the order dated 31/3 of 23 of this honorable court, Lordship, which is page number 85, Lordship.
Yes, yes. Anything elementary?
My lord, we have received the instruction.
Yes. Mr. Mohanta, for whom?
I have got a APSC, my
You have a role.
lord. Regarding age content, I have no role.
It is for the administrative department to
Yes,
make take a call.
Sorry. Already probably. Probably government reject this extent.
Your name is Mridusmita Tarudar.
Yes, yes, Lord.
This 17.3.25 is not the subject matter of challenge.
27.
Lordship, in this writ petition, we have to challenge the order dated 73/23, Lordship, where my representation pursuant to the High Court's order, Lordship, were rejected, Lordship.
That is the subject matter of challenge.
Lordship, this petitioner, Lordship, the APSC issued the advertisement, Lordship.
No, no, that is okay. What is the subject matter of challenge in this writ petition? Is it the rejection order of 17.3?
Yes, yes, your
Then what is this instruction, Mr.?
My lord. Earlier instruction, my lord. Sorry, my lord.
This is not the
My
instruction.
lord.
These instructions have been sent in respect of this case. This case, there is already, this order is already challenged,
My lord. True, my lord.
and you have forwarded this order. What kind of instruction
Sorry,
is
my
this?
lord. I have just now received it.
Additional Secretary of a department, that is his understanding of a legal proceeding. He gives the impugned order to you, which is already under challenge. That is the instruction.
Sorry, my lord, just now I have received, my lord, I am not able to go through this.
Mr. Bora, you advise your clients. This is
My
not the way.
My lord, my.
If they have a difficulty, we can bring them to the court and have an interaction.
Well, some time may be granted. I will.
And this is very poor on your part.
My lord,
You place an you should not have placed this.
sorry, my lord. Just now I
You
have.
don't use your own,
It's my
you
mistake.
don't apply your mind.
My.
See what is written here.
My lord, I have gone through.
It was considered and rejected. That rejection is a subject matter of challenge.
My lord.
So what is
My-
this instruction?
My mistake, my.
No, this is not earlier instruction. This is in regard to this case.
Yes, my lord, there is a earlier petition, my lord, that-
Understood.
Yes,
In person to that writ petition, this order of rejection has been passed.
Now it-
That is the subject matter of challenge. Now, this instruction is in regard to this case. What is this instruction?
My mistake, my lord.
You could seek time. Don't place this kind of instruction. Can you talk to this
My
officer?
lord, sorry, my lord, my mistake, my.
Lordship, may I, Lordship? Lordship, on 17.
What is the nature of the interim order you are seeking in a case condemnation
Yes,
matter?
Lordship, I'm on that, Lordship. On 17.5, Lordship, APSC declare the date of the interview for one post with regard to the one post only, Lordship.
Hmm.
And thereafter, Lordship, my candidature also allowed for with respect of one post only, that is, Lordship.
Interview has not been held over.
No, Lordship, but one date has been declared, Lordship.
See, we are not going to stop an interview. What is the stage, Mr. Bora?
My lord, I have to take instruction, my lord.
Lordship,
We have this on Wednesday next.
My lord. My lord.
You just seek the instructions
My lord.
regarding the status,
My lord.
and we may pass some orders on the interim period.
My lord.
But we are not going to stop a selection process. If you hold the interview, I think we can pass that. You hold the interview, replace the proceedings before this
My
court.
lord, on Wednesday, I will bring.
Okay. Do certain instructions. Do instructions dated 28/4/2023 has been placed before this court, comma, the same appears to be wholly irrelevant and irrelevant as the order dated 17/3/2023, which is the subject matter of challenge in this writ petition, has only been forwarded. Put the para. It appears that the department has not even understood the purpose and object of this writ petition and how to respond to the same. Put the para. Three, Fora, the Learned Standing Council, School Education Department, praised for some time. Put up. At this stage, comma, your Nirola, MSM Nirola, Learned Council, for the petitioner, by drawing the attention of this court to the observations made in the order dated 17/5/2023, has submitted that some interim protection may be granted. Full stop para. So not para. The further submits that as per instructions, comma, the interview is yet to be held. Full stop para. List this case. Para. List this case on
Wednesday.
Thursday.
My-
Thursday.
my-
On Thursday next, only for the to facilitate Sri Bora to obtain instructions regarding the status of the interview. Full stop. This court would, however, consider grant of further time on the same date to obtain complete instructions.
my-
What is
Bless
this?
Lord,
APSC, the score candidate.
Lordship, APSC has declared interview date
Oh,
with
oh.
regard only one post.
Okay.
There I am allowed Lordship to appear.
Okay, let's see. Thursday, date. Huh?
Obliged.
Yes, next.
Obligement.
Yes,
May I please your lordship. My lord, this while school, this ME school was provincialized. As your lordship is aware that 3 teachers has to be provincialized at the time of provincialization. The required science teacher was not provincialized, and that's me. It is not that somebody is there against me in the frame. I'm the
three
lone
have been provincialized. 3 teachers have been provincialized.
two.
One is left, one is still there.
The science teacher is left. It's
Yes,
me.
what is the reason?
My lord, I approached this honorable court, and this honorable court asked them to pass a reasoned order as to why.
Hmm.
The only reason is, my lord, initially they said my name did not come in the dice code.
Hmm.
When we took the plea, that question of dice code is regarding the institution, not the teacher. Whether the institute is registered under that dice data or not. Then now they comes, my lord, it is, I don't find anywhere in the act.
No, if the dice is the problem, then the provincialization will affect all the teachers.
Yes, my lord.
One cannot be left out.
No, my lord. Yes.
What has got dice to do with the provincialization? Yes, Mr. Bora.
Now they passed a speaking order.
Well, at this stage, notice may go, will take.
No, the reasons which have been cited,
Well,
if the petitioner is correct,
well,
obviously will of course give you instructions if the fact projected are not correct. But if it is correct, then this is a poor understanding.
only one.
Dice has got nothing to do with a particular teacher.
Well,
And if on the same dice you have acted, given the benefit to two teachers, then if there are other reasons, of course, you can come up.
well,
This is the exactly reason in the impugned order, my lord. After this honorable court passed an order to pass a reason order.
Heard Sri J. Abedin, learned counsel for the petitioner, who is aggrieved by non-consideration of his case for provincialization of his service
My lord, in spite of recommendation by DA,
pursuant to the fact that not only the school in question has been selected under the 2017 Act, two fellow teachers have also been given the benefit of such provincialization. Full stop. The petitioner further submits that he had earlier approached this court by filing a writ petition WPC 2155/2021, which was disposed of by an order dated 21/3/2022, directing consideration of the case of the petitioner. Full stop. However, while the impugned order dated
6/9, 6/9/2000.
6/9/2022. Why are you so late? 6/9? Why are you so late?
My lord, in between, still there was a contempt petition because they did not consider within 2 months. I understand until that contempt.
However, by the order dated 6/9/2022, the claim of the petition has been rejected, which, according to the petitioner, is wholly on irrelevant factors. Irrelevant factors. Put up para. Issue notice returnable by 4 weeks. P. Bora, Standing Council, Elementary Education Department accepts notice on behalf of respondents 1, 2, 4,
6
6,
and 7 months.
7. Whereas take care for 3, I think B. Gogoi. B. Gogoi runs the Standing Council Finance Department for respondents 3 and 8. Please take care. Run the State Council for respondent 5. All represented. Put up para. Let extra copies of the writ petition be served upon the learned counsel for the respondents by tomorrow. Is there an apprehension of giving benefit to any other person?
No. Nobody is there, my lord.
Yes, next. Yes, what is this, Mr. Goswami?
Yeah, may I please your lordship? Lordship, the petitioner before your lordship is, as was initially appointed in 1999, which is at page 49.
Yes,
This case is a checklist history, so this permit me to just briefly say how we have landed up to.
yes,
this
yes,
stage.
briefly, please. Yes,
Page 49 is the initial appointment order. Now,
Yes,
lordship will recall that in the year 2010, there was a large scale termination of teachers on ostensibly on the ground that there were many teachers illegally appointed or irregularly appointed.
right.
So unfortunately, the petitioner was also one of them who was terminated during that time. Of course, lordship will kindly bear it in mind that she drew her salary from 1999 to 2010 without break. That is on record. I can point it out. Now, what happened initially when they were terminated? They came up to this court. First round, the court set aside the termination order on the premise that the principles of natural justice were not followed. The people were not heard before the termination.
Correct.
So the matter went back to the officer.
Hmm.
The officer reiterated that finding, and thereafter the people again came back to this court. Now the order which was passed when they again came back to the court is relevant. Lordship. Would lordship kindly see the first order, which the lecture 5 that page 64. At the relevant portion, lordship, because the cost title is very long. So
Page,
page 54, the annexure starts, but the relevant portion, that order starts at 102.
this is the first round,
This is the second round. Lordship.
second round.
Second round,
Order starts at
page 102. The order itself.
10,
Cost 102, lordship. This is a division based order.
not 102. Oh, yes, 102, right.
6/2/2015.
Right.
May I just place this order because this order has some relevance.
Yes, sir. This is the second time you had come.
This is the second time. This is on appeal
Appeal by whom?
by us.
No, you said that first round the court interfered because the court found there was violation of the principles of natural justice.
Correct.
Matter was remanded back.
Remanded
It was again rejected by the authorities on the same ground.
Then the writ petition was dismissed.
You came with the second writ petition.
The writ petition was dismissed.
Immediately.
And thereafter we came up in appeal.
WA, or what your WA is what?
One, it is a it's a common order.
Understood, your WA.
I'll just point out. Lordship.
Order we have found is 662.
6/2. We'll just point out. Lordship.
Yes, you proceed. He'll then I will give the.
Now, may I just place this order?
Yes.
Heard the appellants and the respondent. The policy decision taken by the Borough Territorial Council is received on record. The appellants were teachers appointed and working in various ME, MP schools in the Borough Territorial District jurisdiction area. In case of the appellants, that the appellants were appointed in the year 1999 and earlier date, the appointments of the state teachers came to be terminated as being illegal, and that the appointment orders issued by the District Elementary Education Officer, Block Elementary Education Officer in Nalbari District were illegal. Therefore, the termination orders were issued by the Director of Education, BTC. This court in WPC 2182/2009 back had found that the termination orders are illegal and remanded the matter to follow the principles of natural justice. The Director of Education redid the exercise and again terminated the second time, giving the same reason. Aggrieved by the said order, the appellants have filed the writ petition. The learned single judge found that the orders of appointment have been issued illegally and that the order of termination is legal. Hence, dismissed the writ petition. Aggrieved by the said order, the appellants filed this appeal. It is submitted by the counsel for the appellants that the appellants herein were receiving salaries up to 17/10/2006 and thereafter the termination was effective. I will just pause for a moment. I am in a better footing. I have drawn salary from till July 2010. This is only up to 17 to 2006. The BTC as well as the government of Assam took a decision to regularize all those teachers who are in service and are regularly receiving salaries to 17/10/2006. In the first phase of exercise, it is submitted that 221 teachers have been found to be eligible for regularization as per the above norm. It is the contention of the appellants that the appellants are also similarly placed and they should also receive the similar treatment at law. The council appearing for the BTC submits that a policy decision is taken that the persons receiving regular salaries till the month, I think till the month of March 2006 would be regularized and the implementation of the policy is in process.
Hmm.
The government of Assam has also agreed to the said policy. In view of the above submission, the writ appeals are disposed of with a direction to the respondent to effect regularization as per the policy decision of all those eligible teachers who were regularly receiving salaries up to 17/10/2006.
Right.
Needless to say, they have given us a liberty that if we were agreed, we can come back to the court. Now, post this order, Lordship, the state of Assam went up in appeal, review. Of course, after a certain period of time, the limited ground was this, Lordship. Will kindly come, Lordship, to page 106 is a review order.
Hmm.
And the limited ground is at page 106, the second last line. If I may just read, because prior to that is the facts.
Yes.
Second last line. Page 106, Lordship.
Second last line.
Second last line. This
Yes.
is a review order.
Mhm.
Because prior to that, it is the facts being extracted.
Yes, yes, being approved. Yes.
In the meantime, this review petition has been filed by the Finance Department, Government of Assam, stating that the statement given by the BTC, that is the statement to regularize,
Hmm.
given by the BTC was without approval of the Finance Department of State and no approval from the Finance Department was taken. This court, by the order dated 1/3/2001, granted time to the Learned Standing Council BTC to get instructions in the matter, and today, when the matter has been taken up, this court has been informed that during the pendency of this review petition, approval of the Finance Department of State has been taken in this matter. In view thereof, there is nothing to be adjudicated upon this review petition.
Right.
Now, that being the position, Lordships, now would Lordship come to Annexure 7 at page 108.
108.
This is the follow-up to the writ appeal order, which I placed.
Yes, yes.
In pursuance of the Bodoland Territorial Executive Council meeting resolution number 4.1 dated 27/4/2015 and resolution number 4 in the minutes of the department meeting of Education Department held on 26 June 2015 respectively, the Bodo Territorial Council is pleased to withdraw the termination order issued by so-and-so dated 6/11/2008 against Judy Prabha Mazumdar. That is the petition of your Lordship. Assistant teacher, Mazdia Junior Basic School, in terms of the Director of Elementary Education Order, number so-and-so, dated so-and-so with prospective effect. This is followed, now termination having been withdrawn, this is followed by my regularization. This is at page 109, Annex 1. Now this order has some significance because it expects certain things. Why this order has been passed? In pursuance of the Honorable Guwahati High Court's judgment dated 6/2/2015, which Lordship I have already shown, passed in writ appeal 182 of 2013, at in the event of miscase number 183/13 filed by BTC and consequent upon the BTC Executive Council resolution number 4.1 dated 27/4/2015 and departmental meeting of Education Department resolution number 4 dated 26/6/2015 respectively, and in consonance with the approval received from BTC by letter number so-and-so dated 28/9/2015 and on being termination order withdrawn by the BTC by order dated 22/9/2015, which I had shown, Judy Prabha Mazumdar, who was terminated from service by order number so-and-so dated 23rd June 2009, issued from this end is hereby withdrawn and her services are regularized/reinstated as assistant teacher Mazdia Junior Basic School in the scale of pay so-and-so plus under admissible allowance as admissible under the existing government rules. The Lordship will see the pay scale is a regular pay scale. The regularization of the service of the individual teacher shall be subject to the following terms.
Yes, yes.
And
We have read this. We have read.
that's it.
Now, what is the difficulty?
The difficulty is this now. After this, despite this regularization, we were not being paid back. So we came back to that, came to this court, and that matter is pending. What happened in the meantime, since there were so many teachers, and Lordship will appreciate that these people were performing their duties, but the government, for some reason or the other, were verifying their documents, but not paying salary. So these people were accommodated as tutors.
As tutor.
As stopgap arrangements. Some of them. Now that order, Lordship.
Where you are part of that arrangement?
Yes, we were part of that arrangement. Lordship will kindly see. In fact, prior to that, may I just take Lordship to one document? Because this is a very important document, Annexure 11, page 332.
330.
332, annexure 11.
32.
Yes. And I will just straight away come bring your lordship's attention to para 3. Because the BPC is also finding it difficult.
Just a minute.
This one, the
332, yes. 9 September.
9 September 2016.
Yes.
Please come to lordship's para 3.
Yes.
The teachers numbering 668. I'm one of them. I'll demonstrate it. Whose services have been reinstated may be adjusted against the vacant post if BTC so desire for permanent solution of the long-standing issue before the BTC, and the remaining 915 posts will be advertised for that past tenth after the receipt of SIU approval. And if lordship will see together at page 364, serial number 4 is I am the list of the 668 teachers. At 364, serial number 4 is my name.
It's okay, you are there.
Yes, I am there. We are in there. Now what happens? Then lordship will come to this order at annexure 17.
Page
Page 381.
381.
Yes, annexure 17. Now what happened, since there was no solution inside, so there was a stop there. Let us accommodate these people as tutors for the time.
Yes.
So this is the order where it clearly says that I am being accommodated as a tutor in a basic scale. Sorry, in a fixed scale of 10,800 rupees.
Okay.
Accommodate. I am not being appointed. That's very important.
Yes.
Now this order is followed by 14th July order of page 382.
382. Next page.
This order I wish to place because this is the order now that is sought to be cancelled.
382.
Yeah, 14 July 2022, 382.
What
May I
is
just
this?
place this?
Yes, please.
In exercise of power conferred upon Director of Education BTC Kokrajhar by Secretary BTC letter dated 13 September 2005 and in pursuance of the approval of BTC authority by letter dated 14 July 2002 and the Government of Assam communicated by number 9 to 2002, the services of Juri Prabha Mazumdar, assistant teacher Mazdia Junior Basic School, who was reinstated in service as per memo number so and so dated 1st October 2015, issued from this end is hereby regularized as assistant teacher by Suren Chandra Das, retired and posted at 786 Kalakuchi LPS in the scale of pay so and so. Now, may I just pause for a moment? This order could perhaps be an order of adjustment because my regularization is of 2015, which order still stands. That earlier order. Though they have used the word regularization,
yes,
but it would be an order of adjustment because my regularization is from 1/10/2015, which order is not the same and is still part of. Now what has happened is the impugn order. Thereafter, I resigned and went to join the new school. In terms of this, I resigned. The resignation is page 383, and at 385 is the joining report. I went and reported myself in a new place.
385.
Five. Yeah, no.
Joining.
This is join. I joined in
18.7.
Yes, 18.7. Now, lordship will see the impugn order. Why we are before.
Yes.
As page 380. 27 July 2020. The incumbents illegally and irregularly teachered in the year 1999 who were appointed as tutor assistant teacher in both LPS and MES dated 1/4/2002 at the Baksa district and whose names are appeared again in the service regularization order 14/7/2022 issued from this office is hereby treated to be cancelled. What is the reason? Why it was cancelled?
17.4 is sought to be cancelled.
Yes, no.
14.7.
14.7.
By which you were again sought to be regularized and posted.
Yes.
The regularization issue is something which you may consider.
Yes.
But you were given a substantial posting in an LP school, which you had joined on 18.7. Immediately after the joining, this order came cancelling.
Cancellation for what purpose? What is the reason discernible? So therefore, we are before your lordship that now everything, my whole right is now clouded.
Now, why are you late for?
Lordship, I have
July
explained that
15th.
in para 35.
No, but there is
I
no.
appreciate there is a there is a delay.
There's an inordinate delay.
I truly appreciate there is a delay.
Not to even consider your interim, even in your merits, merits of course will consider your service, but interim order, you're also praying for interim order.
Lordship, my interim order is very simple.
What is the vacancy position of the vacancy which had arisen
That
on
on verbal instruction.
on 786 Kola?
Yes, I'm instructed to tell Lordship
Hmm.
that the vacancy is still there. All that I want at this stage is let me discharge my duties, subject to the outcome. Ultimately, if I don't join, the children also suffering there.
Working in the post.
To discharge your duties, that part is very difficult. Yes, but we'll do something to protect you. Yes.
First thing your Lordship has rightly pointed out, this is an order of 2022, Lordship 7. Lordship will kindly read that impugn order, Lordship 386. The incumbents illegally and irregularly teachers in the year 1999 who were appointed as tutor, assistant teacher in both LPS and MES dated 1/4/2022 under Buxar district and whose names are appeared again in the service regularization order dated 14/7/2022 issued from this office is hereby treated to be cancelled. Lordship, she was appointed as tutor. Subsequently, her name again appeared in the regularization order. So authority thinks this is wrong. This was wrongly done.
So, Mr. Nayak, there are more than one reason not to accept your submissions immediately.
Lordship, at this stage, Lordship, I am also not aware what is the exact.
See, the issue was resolved
Lordship.
finally by number of cases, including the writ appellate judgment. And therefore you had accepted. Review by the state was on a ground which was also rectified, that approval part. Thereafter, since you are taking time, this tutor thing was only an accommodation for a temporary period, which ultimately you had finally resolved by passing the order of 14/7/2022. You said that you are again regularizing. Of course, that part is also maybe a grievance of the petition, which will maybe from that date or the earlier date, there is no question of continuous regularization.
I'm so grateful.
But the second part of cancelling, we'll definitely examine. And not only because of the fact that it touches the livelihood, there is a checkered history and the litigation seems to be in the favor of the petitioner.
Lordship, her earlier accommodation as tutor, that has not been touched, Lordship. This is apparent from this order itself, Lordship. As she was accommodated as tutor, Lordship, subsequent.
Then Mr. Nayak, what was the...
Lordship, in my humble understanding, Lordship, the meaning of this letter is that her name has she has been already accommodated tutor, so her name should not have appeared in the regularization list. That is the meaning of this. That is the primary.
No, even if that cannot be a permanent arrangement. When the court has interfered and while passing this order, again the same mistake you are doing.
Court interfered only in respect of 221 numbers of person. Lordship, she has nowhere stated that I belong to that 221.
That part
Lordship,
will examine.
Subsequent orders, your Lordship will see.
But Mr. Nayak, independently, if rehearse the history of this case, before you pass an order of this nature, aren't you required to give them an opportunity? You forgot the history. We don't take into consider history, what has happened. But this order is definitely affecting her means of life and livelihood.
Lordship, at this stage,
you are taking an adverse view against her.
No, at
least the minimum requirement to give her an opportunity, a notice that this is what we propose to do.
Lordship, at this stage, your Lordship will definitely issue notice. Lordship will give me an opportunity.
No, but you don't fill up that post of which had arisen in Mazdia. Not Mazdia, Kalaguchi. 786 Kalaguchi. You don't fill up that post.
Not already filled up. So this is an order of July 20.
That will observation. You maintain status.
Otherwise, her interim prayer is a final prayer, Lordship.
No, that we have realized. Heard.
Lordship wanted to know my writ appeal number.
Yes.
Writ appeal 321 of 2010. Lordship, that is the stage 79 of the paper.
Okay.
And
okay, we'll pass out. Heard. 3M Goswami. Learn concept for the petitioner. Have your seat, please. Have your seat, please. The writ petition has a checkered history. The petitioner was initially appointed as an assistant teacher of Mazdia Junior Basic School in the district of Baksa, within bracket Arspel, Nalbari, by an order dated 4/12/1999. She claims to have been receiving her salaries when suddenly, in the year 2010, the services of the petitioner, along with a host of similarly situated persons, were cancelled. Full stop. This led to the first round of litigation, which was, and the writ petitions, including the writ petition filed by the petitioner, being WPC 2152/2009, was allowed by this court primarily on the ground of violation of the principles of natural justice. Full stop. The matter was accordingly remanded back to the authorities to take a fresh call. Full stop. Para. However, the rejection was upheld, leading to a second round of litigation, which, however, was dismissed by the learned single judge, holding that the initial appointments were illegal. Full stop. The petitioner, along with a number of similarly situated persons, had preferred writ appeal, and within bracket the appeal filed by the petitioner being WA 3/21/2010. Full stop. The Honorable Division Bench, while order dated 6/2/2015, had, however, disposed of the writ appeal, as the Honorable Bench was apprised that a policy was taken by the BTC, was adopted by the BTC for regularizing 221 teachers, regularizing teachers who were teachers who were in a similar situation, and 221 teachers were already regularized. Full stop. This court, the Honorable Division Bench, had accordingly passed a direction to give the effect of regularization to all such teachers. Full stop. Though subsequently, a review was preferred by the state within bracket finance department, bracket close. The same was also disposed of by the Honorable Division Bench as the ground which was cited for the review, namely lack of approval from the finance department, was already rectified in the meantime, and the state statement was recorded by the Honorable Division Bench. Full stop. As a consequence to the legal to the proceedings in this court, the authorities had passed an order dated 22/9/2015, terminating the withdrawing the termination order of the petitioner, and while another order dated 1/10/2015, the services of the petitioner was regularized with prospective effect. Full stop. Para. Since the petitioner and similarly situated persons were still not paid their salaries, new writ petitions have been filed which are pending. Full stop. it appears that in the meantime, the BTC had made certain arrangements, and by an order dated 9/9/2016, an order for adjustment was passed, according to which, by an order dated 1/4/2022, the petitioner was accommodated as a tutor in the Mazdia Junior Basic School, which was on fixed pay. Full stop. The petitioner projects that the state accommodation, as the expression suggests, was a temporary measure till the regular posting of the petitioner pursuant to the policy decision of the BTC, which was also endorsed, which had also attained an endorsement from this court. No, I think which was also endorsed by this court. Full stop. Para. Subsequently, on 14/7/2022, an order was passed posting the petitioner as a regular teacher in the 786 Kolakuchi LP School in the district of Baksa. Full stop. Though the petitioner submits that there is an issue on the use of the expression regularized, and as to from which date such regularization would take place, the grievance of the petitioner is that even after her joining, while a joining report dated 18/7/2022, the impugned order has been passed, cancelling the order dated 14/7/2022. Para. Sri Goswami, the learned counsel for the petitioner, submit that the impugned order dated 27/7/2022 is expressly illegal, as apart from the fact that no reasons have been cited and opportunity granted to the petitioner to before passing such order, the background and history of this case does not at all justify passing of such order. Full stop. Para. Sri Goswami also praised for an interim order to allow the petitioner to render her to allow the petitioner to discharge her duties as an assistant teacher in the 786 Collaborate LP School, where she was appointed on an existing vacancy. Full stop. Para. Issue notice returnable by 4 weeks. Mr. Nayak, for whom?
I'm appealing for
First is the State Department of Elementary, Preeti Bora, the Standing Council, Elementary Education Department, accept notice on behalf of respondents 1 and 8. Finance. I think let Chalia appear. You don't appear for both. Let Chalia is there in the court. Otherwise, Priya Chalia, Standing Council Finance, appears for respondent number 2
and for
Two.
finance on the lot.
by 2.
And I am appearing for 3,
P
4,
Nayak, Standing Council BTC for 3,
4,
4,
6, 7,
6, 7,
9,
9,
and 10 lot.
and 10. Ardhor. Why WPTBC? Why WPTBC is a department? Ardhor, Standing Council, WPT and BC department. Accept notice on behalf of respondent 5. Why 5 is the respondent? What role is it? What to do? No, there's nothing to do. At this time, let him, but you strike, later on strike of the name. Right now, if we strike of the area of parties will be, that will be considered. We're not touching the suspect now. Okay. let extra copies of the writ petition be served on the learned counsel for the respondent. Full stop. Sarah. As regards the interim prayer, Sri Nayak has submitted that though that submitted that there is inordinate delay of the petitioner in approaching the court, and further that by the impugned order, the 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 arrangement so far as accommodating the petitioner as tutor by the order dated 1/4/2022 has not been effected. That was your submission.
It appears from the reading of the
And he further submits that it appears from the impugned order that the arrangement of accommodating the petitioner as tutor by 1/4/2022 has not been effected. Full stop. Sarah. This court has given its anxious thought to the aforesaid matter. Full stop. Though an interim or though a prima facie case for passing an interim order is made out, the aspect of delay cannot be fully overlooked. Full stop. Therefore, balancing the equities, it is provided that the post in which the petitioner was appointed as a regular teacher by order dated 14/7/2022 in the 786 Kolaguchi LP School shall not be filled up, if not already filled up, without taking the leave of the court. Full stop. It is further observed that the force and restraint would, however, not be applicable if the case of the petitioner is considered for appointment in the state court. Not appointment, for reinstatement in the state court.
It will be adjustment. I have already been reinstated. I am in the job.
Is put back in the state court. Okay.
Grateful.
Yes, Mr. Nand.
This is the music teacher, my lord. Petitioner has been working.
Music. What do you do?
Working, my lord, since
No,
1995.
music has many disciplines. What do you do? You sing or you play or what?
Singing, playing, everything, my lord.
Singing and playing are different. One may play and sing together. You play on some instrument.
Instrument.
What instrument?
Instrument, my lord, where generally harmonium and others has been taught to the teachers and singing, my lord. Music post is there. Lordship will find the
No,
particulars.
you have not answered the question. You are teaching music. You are a music teacher. What do you teach? What kind of music do you teach?
Singing and playing of, my lord, harmonium and instrument. Lordship will find.
We call your client to the next program of High Court.
You may come, no problem. But Lordship will find.
You are taking a huge risk.
Page 19, no, my lord, 3 of us. 19, Lordship will find the proposal was sent for provincialization of a school to the, my lord. And at that time, my lord, post of music teacher was also there. And while.
But this is not a 17 Act. This is the 17 Act.
No, my lord. Under 2011 Act, my lord. It was provincialized in 13. Lordship will find page 20. The provincialization order. At the time of provincialization, my lord, the post of music teacher was dropped. And since, but she has been retained. She is working on honorary basis.
Do you have any right for consideration?
And my lord, there is, as per rule, there is a post of music teacher, my lord. And thereafter, she filed application.
It was provincialized, recognized in the year 93. You
no,
said
it is provincialized in 2013.
No, recognized.
Recognized earlier, and provincialized in 2013.
Yes, what do you say?
My lord, this school is provincialized 1/1/2013 under the Act of 2011. So, and my lord, at that time, she was sitting over the matter and she was so
and she did not come to the Honorable High Court to challenge the provincialization. So now she is coming with this inordinate delay.
You're coming after 10 years.
No, but just let's find page 23. That is the notification regarding qualification. 28 July 2014. 14 notification, my lord. And after that, my lord, petitioner filed representations, lordship will find in page 22 and 2014. And
Is
page 22, my lord. My representation.
your representation is of January 2014,
Yes, my lord.
and this notification is of July 2014.
And thereafter also, my lord, I have filed representation. And lastly, my lord, I have filed in 2023. Several representation has been filed. They are proposing the matter of the government money. Government is now considering whether missing post will be created or not. So my only prayer is that, my lord, my representations may be disposed of.
After 10 years, they're not going to direct that. Mr. Sharma,
My lord.
we'll leave that point open, delay point. You take instructions if this representation was received or disposed of.
Representation is on the basis of 1/1/2013. It is 2011 Act, my lord. Now it is 2017.
Not a fit case. Sanat.
Therefore, in this juncture, your kindness will be pleased to provincialize my service as music teacher with effect from 1/1/2013 and oblige here.
Heard PS not done counsel for the petitioner. Also heard Sri U. Sharma, still understanding counsel.
Lordship, may pay that, my lord. I have to take instruction. I may be allowed to withdraw, my lord. Next take time. Otherwise, my lord, will be.
Okay, we'll U. Sharma, understanding counsel, elementary education department, secondary education department. Full stop. The petitioner claimed regularization of her service as a music teacher in the Putkibari HS High School in the district of Dhubri. However, Sri Sharma, still standing counsel of the department, submits that the regularization, the exercise of regularization was done in the year 2013.
Yes,
13 under the Act of 2011, and this writ petition has been filed after almost a decade. Full stop. Though this court has also appeared that though representations, one representation was filed in the year 2014, though one representation followed by another representation dated 9 February 2023, it appears that the petitioner has been grossly negligent in approaching this court, which exercises equitable jurisdiction. Full stop. It further appears that the last representation dated 9 February 2023 has been done only as a means to approach this court. Full stop. Para. Be that as it may, at this stage, Srinath prays for some time to obtain instruction as to whether this petition instruction in the interest of justice, matter stands adjourned. It will be listed after 2 weeks. Welcome.
Has taken a agenda for appointment for employee after the retirement of one Mr. Chandra. It is on page 24. And after that, they have the meeting was conveyed. It is on next 4 page 33,
where I have been appointed as a grade 4 employee on 8/7/2012. So since 2012, I am directly working there.
Mr. Sharma,
My employee, more one, my lord, it was appointed by the managing committee. My lord. Managing committee has no role to appoint.
So
Grade 4 employee.
this two lordship, but I am submitting a lordship in Annexure 5 case 42. The government portal where my name has been as a use of employment code and
Page?
page 42. So they use code TE teacher code and my name is as a Indoti Fora. So here and let me come to page 44 where the name of the post grade for appointment as a type of temporary. So
Mr. Chetri, we cannot grant you any relief. At best, we can say that in the selection process,
if they have taken even weightage on that,
that much,
They-
nothing more than that.
only that much.
After the provincialization, the managing committee doesn't have any jurisdiction or power. Arts free, H3 Learned Council for the petitioner. Also heard for you, Sharma. Learned Standing Council, Secondary Education Department. Sarah, considering the facts and circumstances of the case and as agreed to by the parties, the instant petition is taken up for disposal at the motion stage. Full stop, Sarah. The prayer in this petition is with regard to regularization of the service of the petition. Full stop, Sarah. The fact projected is that the petitioner was engaged as a talkative against the sanctioned vacant grade 4 post in the Chenijan CHENIJAN High School, Jorhat, pursuant to resolution adopted by the School Management and Development Committee within bracket SMDC held on 24/3/2012 and 29/4/2012. Full stop. The petitioner claimed to have joined the said post on 25/3/2012.
No, it is on 8/7/2012. It is on page 30.
8/7.
Yes, it is on page 33.
What have you written in your synopsis? Petitioner claimed to have joined the said post on 8/7.
12.
8/7/2012 and also claimed to be rendering continuous service without any break. Full stop. The petitioner relies upon a communication dated 30/5/2022 issued by the headmaster of the school to the inspector of schools, whereby a resolution of the general meeting of the school dated 29/5/2022 has been forwarded, wherein the aspect of regularization of the service of the petitioner is there. Full stop. The petitioner accordingly prays for a direction for consideration of his case for regularization of his service. Full stop. Para. On the other hand, Riyu Sharma, Learned Standing Council, Secondary Education Department submits that the relief claim is on misconceived and erroneous grounds. Full stop. He submits that the initial appointment done by the school by the assemblies was without any power or jurisdiction, as the school in question was a provincial school. Full stop. He submits that since the initial appointment itself was not in accordance with law, comma, the question of regularization of service will not come in. Full stop. He further submits that for claiming regularization, comma, one has to meet not an incumbent has to meet certain criteria which are not met by the petition. Full stop. Para. After hearing, comma, this court finds force in the contention of the learned standing counsel of the department that an SMDC does not have any power or jurisdiction to make any appointment in a provincialized school. Full stop. Therefore, this court is of the opinion that the prayer made in the petition cannot be accepted. Full stop. However, while dismissing the writ petition, it is observed that the petitioner would be at liberty to participate in any ensuing selection for the post of grade 4 in the aforesaid school, in which case the experience gained by him may be a relevant factor for consideration.
I'm continuing in this. So, continue.
That will not say anything.
Howell.
Representative.
May I please join us?
Yes, madam.
Lordship, Lordship, this is the contempt petition. And before jumping straight into the order, I would like to briefly state the subject matter of the earlier written.
Doesn't require, not required. Let us see the order.
Okay, Lordship may take up page 76.
76.
Yes, sir.
Where is the operative portion? What is the operative portion?
May I read your Lordship? Paragraph 11.
Yes.
The aspect of condoning the upper age limit for any recruitment is presently governed by the notification dated 3/5/1951. Clause 4 of the notification dated 3/5/1951, which governs the law relating to relaxation of upper age limit, is extracted as in pursuant to the provision of Article 309 of the Constitution.
Now come to paragraph 16
Yes, sir.
at 78.
The Secretary may pass his reasoned order on the individual applications on being filed. It is requested that the individual applications be submitted forthwith and the Secretary to pass respective reasoned order within a period of 2 months from the date of receipt of the individual representation.
Where is your application?
The representation will find at page 80.
80.
80.
What is 83? How many petitions are there?
Lordship, there are total 11 petitions.
These are
We
all your individual representation.
Yes, your Lord. Yes,
No orders have been passed.
no orders have been passed, and 2 months time period has also been expired, your Lord.
What is your name?
AM Department
At your number?
54.
AM?
Because
Where is your name?
it is reflected in the first
What's this? Huh? Item 50?
54.
54. Okay. Yes. Third AM de Costa, Learned Counsel for the petitioners who by means of this application has complained about willful and deliberate disobedience of the directions contained in the judgment and order dated 35/20/22 passed in WPC 2238 of 2020. Para. In by the aforesaid judgment, a direction was given to the secretary of the department to consider the cases of the petitioner who were required to submit individual application. Full stop. The learned counsel has submitted that individual applications were filed, which are also annexed to this petition. Full stop. However, till now, nothing has been done upon the state application. But there are issue notice returnable by 4 weeks. That step be taken for issuance of notice by registered post VCD served by tomorrow.
It's content that order was passed on 25/5/2022, page 12.
I heard MSK Devi, Learned Counsel for the petition, who by means of this application, judgment and order dated. Now ordered it to 25/5/2022, substance WPC 3384/2022. Second line to 44. By the aforesaid order, this court had allowed the petitioner to submit a representation to the Director of Elementary Education with regard to her claim, which was directed to be considered by the director within by passing a regent order within a period of 3 months from the date of presentation of the representation. The Learned Counsel has also referred to the communication dated 26/9/2022 to the director requesting compliance, which, as per the petitioner, was also received.
It is also content petition matter. The order alleged to have been violated is at page 18, 11.
You don't say alleged to have been violated, you are on this side now. For you, it's not alleged, for you, it's violation.
Yeah, right.
If you are on that side, you say alleged. You forget. Yes, what is it?
In that, governing body was constituted by deputy committee.
Where is the direction?
It is at page 19,
19 years.
As instructions are not received, document to despite the order dated 15/20.
Suspend the operation of resolution in the minus of the conference of. So what will happen?
Now, the TC has not taken any action. Rather, that governing body still continues.
Where is your communication?
Communication next page, lordship on 5/4/23 itself we have
Where?
endorsement, lordship finds at the bottom of the annexure C.
You should give a representation.
Representation, my lord, I have enclosed in a separate affidavit, my lord. It is not before your lordship today. Inadvertent.
When did you file?
This morning.
Okay.
Representation was is dated, my lord.
Okay. Heard MSP Chakraborty, Learned Counsel for the petitioner, Arambha Network, order dated 31/3/2023 in WPC 1375/2023. By the said order, this court has suspended the operation of the resolution dated 11/10/2022. The learned counsel has submitted that on 5/4/2023 itself, the copy of the order was furnished to the authorities, and
Then my lord, on
and it is submitted that an additional affidavit has also been filed annexing
18
the representation
dated
by
25
which such order was forwarded. It is the submission of the learned counsel for the petitioner that in spite of such interim order, no action has been taken for compliance of this thing, as will be reflected from the notice dated 6/4/2023, annexed as Annex 4. Correct?
My lord.
Issue notice returnable by board executive. That was by tomorrow. Yes, next.
May I please your lordship kindly to make up for the time being lordship? Thank you, learned counsel, FU Bhatia is a left.
The department as per order, and the record. Are there any,
Records have earlier has otherwise been sent to you.
yes, sir.
Okay. They are on Thursday. Okay. As per you, Sharma, learned standing counsel of the department submit that pursuant to the order of this court, though the records have been transmitted, there is some the same is not readily available. We accordingly prays for some accommodation. List on Thursday. Next.
In this matter, R. Mujumdar is appearing. Here, my lord, on the last occasion, that is on 19/5/23, we were directed to bring the record. My lord, here we seek some more time.
17 matter. Why?
My lord, the record will be crucial. I think, my lord, on the last.
Patori, what is this matter about?
In fact, my lord, your lordship can dispose it of. Close the petition. So whatever we approach this honorable court to ascertain that whether there is any regularization process initiated against to regularize our service. But they said that according to their affidavit, that they have not adopted any policy to regularize service. That is why my case can be not in my mouth, my lord.
Heard 3S Kotoki, learned counsel for the petitioner. Also heard 3A Fukan, learned standing counsel for the school education department. The grievance of the petitioner is with regard to regularization of their services pursuant to a policy decision by the department. However, the aforesaid basis of filing the petition has been refuted in the affidavit by the department, in which it has been stated that there is no such policy for regularization. In view of the aforesaid disputed questions of fact, this court is of the opinion that the present petition is not maintainable, and accordingly the same is closed. However, this court makes an observation that if and when such a policy for regulation of the services of similarly situated persons are taken, the cases of the petitioners may be considered in accordance with law.
Right.
Thursday. We don't mind who is there? Monday. Monday. Next Monday is what? On 5th. Or not 5th. 5th of Monday. 5th.
Your Lordship, on 26th May, Your Lordship, we have received a paragraph. We'll be filing an affidavit.
Training Council, Secondary Education Department submits Elementary Education Department submits that the instructions have been received in the main day and sometimes will be afforded to file an affidavit in opposition. 3 weeks. Considering that this writ petition is of the year 2018, 3 weeks time is granted for the state purpose.
They may also keep the records straight.
Is there any interim order? No.
May I please, Your Lordship? In this matter, the petitioner was engaged as a cook in the concerned school for the year.
But this is a cook.
Yes, sir. But
What school?
in the LP school, 191 Deshabandhu Memorial School.
Cook for midday meal or what?
Yes, Lord.
Then what had happened?
Then, Lordship, she was discontinued from her service from 18/5/2015, when she objected that the wife of the president of the managing subcommittee being engaged as a cook in her place. And after that, she approached the appropriate authorities, respondent number 4, and the deputy commissioner to consider her fair, but again, her grievances was not dealt with, and after that, she filed a great petition in 2017, which was disposed of, which was with the direction to the respondent number 4. Look into the grievances of the petitioner, and then the DEO requested the president in 2017, October 2017, and the head teacher to engage the petitioner as a cook come helper of the state school, even though the head teacher complied with the order of the DEO, but the president, who is respondent number 5, didn't comply with the order.
Now your grievance is against which order?
Against the president, who is not allowing the petitioner to sign in the attendance register as a cook.
But is your discontinuation
We have
set aside? Was your discontinuation, which was the subject matter in earlier petition, was it set aside by this court? You said that you were working as a cook.
Yes.
You were discontinued from your service.
Yes.
They wanted to appoint somebody else, isn't it?
yes,
They wanted to appoint the wife.
president's wife
Wife.
allowed to sign instead of the.
That is it. Was that discontinuation in service of the petitioner interfered by this court in earlier proceedings?
Yes, sir.
Court has interfered.
Yes.
Court has only asked,
And the direction
directed to consider your case.
Direction was yes, Lordship, and
It was not interfered in direct manner. Yes, madam, who is appealing?
okay, respondent have not filed any affidavit yet.
They filed affidavit.
No, Lordship, have not filed affidavit.
Nobody has filed affidavit.
No, Lordship.
Here for whom, madam?
SSS.
SSP. Who is the contesting respondent? SSP.
No, Lordship.
Then-
Pending
Managing committee of what?
managing committee of the
Anyone appearing for the managing committee?
silence.
Notices issued.
Yes, Lordship.
When? Served or not?
Yes, Lordship.
ID cards upon respondent have been received back and placed on record. Has 5 has appeared.
Yes, sir.
Whose 5? Names shown or not?
No, 5. F.U. Borbhuya, Suleiman, H.R.A. Chaudhary, Borbhuya, Suleiman. They have filed affidavit.
No, Lordship, I have not filed.
Where are they? 3 counsels are there. Now none is appearing. Borbhuya was here some time back, I think. Yes, he was there. We'll have it after some time. I think Borbhuya was still in the court.
Okay, Lord.
Try to locate them. You know them. Somebody who knows Borbhuya, F.U. Borbhuya. Or you can contact Mr. H.R.A. Chaudhary. Since the contest is with the school managing committee, I think they will be the. They have to file their report. Yes, next. We'll have it after some time.
In this case, my lord, the school was provincialized lordship as per my lord 11 Act lordship. The school was my mixed medium school, my lord. In the definition, my lord, there was the definition, my lord, mixed medium school. One unit was my lord Assamese medium, other unit is my lord Uru medium lordship. And
Yes,
mixed medium-
response. Who is appearing? Mustari, you're appearing. BTC. No affidavit has been filed. Why? 18 matter.
My lord, Oro unit was not provincialized. Assamese unit provincialized along with the headmaster, my lord. Administrative head is common law. As per my lord, the strength of cadets lordship in the schedule,
Who is the contesting respondent from whom the response is to come?
the BTC is there, my lord.
BTC.
The higher secondary division is there.
Yes, who will take the call? Mr. Sharma, BTC or you? Now, this subject matter is slightly different. It pertains to provincialization of service. Can the BTC on their own do, or approval of the state would be required? At least you get the instruction, Mr. Mustar, Mr. Sharma. Matter is pending since 18. Doesn't look good. You're not equipped with the instructions till now.
My lord, provincialization order is at best 51. And if it was provincialized by the state,
We'll grant you another opportunity. Come up with instructions. Oh, wait. Have you seen the last order? Have you seen the last order 8/5/2023? Have a look at the last order. Doctrine of non-traverse. Matter is serious for you. Though this court, by the last order, had observed that the doctrine of non-traverse would be invoked, in the interest of justice.
And, no, we hope. A prayer has been made on behalf of the department for a last opportunity. In the interest of justice, that a last opportunity is granted as an exceptional circumstance. Directing listing of this case on on 16th of June. If you don't come up with instruction, 16th of June will dispose of it. It will be decided, it will be deemed to be uncontroverted.
May it please your Lord. Matter relates to the petitioner was
Affidavit filed.
no affidavit.
Check
Why-
on
why
inspection
fail?
in this matter, Your Lordship. I have instruction in this matter. Here, my lord, the joint secretary has written to us, Your Lordship, that my lord, the case of the petitioner, the name of the petitioner was not found in, no record was found in the screening committee report regarding the petitioner of WPC 7536 of 18. That is the
He put this on record. He should be given an opportunity. 3A Fukan, Leonard, Standing Council, Elementary Education Department submits that written instructions have been received as per which the name of the petitioner was not found in the screening committee report. Full stop para. Let the said instructions be placed on record by way of an affidavit so as to give the petitioner an opportunity. Full stop para. Let such affidavit be filed within a period of 3 weeks from today. Yes, next. Madam?
Yes, Your Lord. My lord, this matter relates to dismissal from service the petitioner.
Yes, we are taken up on the other occasion.
Yes, my lord. And see at page 28, my lord, the inquiry report, my lord. Your Lordship may kindly see the last paragraph. Here, my lord, the charges, allegations are proved and established and ex parte against the gov servant, Manoj Kumar Sharma. That though as per the above findings of the inquiry committee, the allegations against the gov servant Manoj Kumar Sharma has been established to be true, but during the period of inquiry, the committee also observed that the behavior and attitude of the government servant, Dr. Manoj Kumar Sharma, was to some extent indifferent in nature, which may be due to his illness, as shown in the document number 67. So they themselves have admitted that the petitioner was ill, my lord. In fact, he was undergoing treatment at that period, my lord. He was mentally ill for some time.
Okay.
Then your lordship may kindly see the order, impugn order, my lord, at page 31, my lord, the last 2 lines. My lord. The inquiry committee observed that the allegations are proved, but also observed that the indifferent attitude may be due to his illness.
Yes.
In spite of that, my lord, punishment has been imposed by dismissing him from service, my lord. And moreover, my lord, he should have given second show cause notice, my lord, before imposing punishment, my lord. That has not been given.
No, you had shown cause against the come to page 32, the third paragraph, second paragraph. The delinquent officer, government servant submitted representation 6/11/17. You had submitted representation.
He has submitted, my lord, but before, my lord, imposing penalty, my lord.
That is not required after the 42nd amendment. What is required
But
is
in case, but this is regarding major punishment.
major punishment. That is not required.
And regarding his illness also, my lord.
What is required is on the acceptance or non-acceptance of the report of the inquiry officer.
Yes.
If it is adverse against you, then you have to be given an opportunity that you persuade the disciplinary authority not to accept the. But there is no requirement in law to have your views on the penalty. That has been done away with the
Given
42nd
an
Amendment.
opportunity, because my lord, earlier also.
You had given the opportunity.
Earlier also he could not appear in some.
No,
case,
that is
my
a
lord.
different aspect. That will consider definitely.
And
Your
regarding
mental element. Yes, Sir Das? Yes, what do you say? Affidavit filed.
no, my lord.
Yes, sir, affidavit.
Records were called for, my lord.
Affidavit has been
Records have
filed.
come.
Affidavit file, records were called for.
Records have come.
Who is R2? R2 is whom? Director.
Yes, sir.
You file affidavit. Yes, madam, affidavit has been filed.
And my lord, records have been called. Your lordship may peruse the records, my lord. Medical certificates, medical documents are also there in the records.
Now we'll have this for consideration on a hearing date. Tuesday next for disposal. Have the records ready. Okay. And madam, you can come prepared with some cases, relevant cases touching the mental element.
Yes, my lord.
It appears that pleadings are that the concerned that the contesting director and the contesting respondent, namely the director, has filed the affidavit in opposition on 17/3/2021. The petitioner, represented by M.S. Chaudhary, the learned counsel, has submitted that no rejoinder is required. Not file rejoinder.
My lord, I'll file, my lord, because I have not received the copy. Copy is not there, my lord.
How is it possible? How is it possible? Oh, no, it will take a minute. MSSB Chaudhary learned. Somebody has received. It's a different matter. He will give you another copy. But
Yes, my lord.
have a look. Have a look at this.
Yes, my lord, there is the other counsel, my lord. Yes.
Are you? Do you have the copy or not? People, MS Chaudhary, the learned counsel for the petitioner, submit that do it appears that copy of the affidavit in opposition was served, comma, the same is not readily available with her. Three, ask the learned training council. This is what education, what higher education department has readily accepted to furnish another copy to the learned council for the petition. MS Chaudhary prays for and is granted 4 weeks time to file rejoinder. Please after 4 weeks for admission.
Is, I was directed to file affidavit to the commissioner secretary and
Run some time. MS Das, the learned training council, higher education, submit that the affidavit in opposition would be filed shortly. Let such affidavit in opposition be filed and the matters be listed after a week.
may
Yes.
may I please, Your Honor? I have filed an ILOC in item number 25, that is in the petition number 8795/2019.
Yes.
For implement as respondent.
Your IA is 1073.
Yes, sir.
We can pass orders. Yes, 1073. How are you connected?
Lordship.
How are you connected?
All are the applicants are all graduate in engineering and they are deserving candidates for the post of lecturer in the polytechnic colleges, Lordship. But what happened, Lordship? Various relevant facts neither has been placed before the honorable board by any one of the parties.
You are UB Sharma.
Yes, sir.
Or UB Sharma. Learned. Yes, sir.
No, I'm not in this.
Who is there for the petition? Adidas.
Mr. Ditas.
Mr. Didas or any of his colleagues, associates, Didas. Somebody was here. Who's there with him? R. Sharma, H.K. Nath, K. Mohammed. Madam, you're at Mr. Didas. Where are you? Where you are not on record? Okay. There's an IA for implement.
Proceed, will be filing objection, Your Lordship.
In the implement. Why?
As per the instruction.
কি করো? Concept for the applicants who by means of this application prays for allowing the applicants to be included as respondents. Full stop. He submits that the subject matter in question would also affect the applicants and therefore they may be heard in the adjudication process. Full stop. MS your name? S. Sharma. MS S. Sharma, learned counsel for the opposite party petitioners. However, submit that she would like to file an objection against such prayer for imprisonment. How much time? 2 weeks. Let a period of 2 weeks be granted for filing such objection, whereafter this IA would be considered. Mr. Mohanta for APSC.
I am actually for my PhD.
And Madam Bora?
25.
Also heard TJ Mohanta and Senior Counsel appearing for the APSC and MSP Bora. What is the response number? As per 4 to 18 in item number 26. 26 to W3. 6000521. Yes, next.
Pursuant to earlier order, my lord, we have filed our affidavit in opposition to the matter.
Who's for the other side? None appears for the petitioner on call. Full para DK Roy, standing counsel SEBA, however, submits that the affidavit in opposition has been filed today, which is not tagged with the record. Full para in the interest of justice, comma, list after a week by tagging the affidavit in opposition said to have been filed today.
May I please? But for the impugn order dated 26 to 2021, the
Mr. Ali, there was a matter where Mr. H.R. Chaudhary, F.U. Borbia had appeared. We had passed over for the time being. We'll have it immediately after this matter. Which was that matter?
item 21.
21. 20. Item 20. Are you aware of that matter? 20. 20. Mr. Your colleague, Mr. F.U. Borbia, inform him. Okay. Inform Mr. Chaudhary's name is also there. Yes, what is this matter?
Here in this case, my entity is required, my lord, is on the.
Who?
He told me I alum. Presence of I alum is required, my lord, because he's I'm
NCT.
entity is required. He's
Affidavit filed.
affidavit. They're supposed to file, but they told me that they will not file it.
Mr. Ali, of whom?
Private respondent, ma'am.
As per filed affidavit.
Their affidavit, my
And Mr. Sharma? Records, affidavit, instructions, anything?
mainly NCT is required, my lord, because the director, while issuing the impugn order, has stated that my degree of BEd is not legally valid, but it is not correct because the IGNOU has clarified that the degree of
Your degree is from which institute?
IGNOU
IGNOU.
is valid. NCT has
Which center?
IGNOU, my
That
lord,
is distance education, isn't it?
Yes, it-
It is not off campus.
for commercial certificate. For commercial.
NCT has given the recognition. My page 33 is the recognition order.
How are you?
So the impugn
Yes.
through the impugn order, my lord, page 30, the type of,
No, how are you connected, Mr. Ali?
because he is not also qualified, but he has been given the chance to hold the post of headmaster. That is the
So if you are given the,
and I am entitled to hold the charge.
so that is disconnected.
He is also otherwise not qualified.
He has a beard or not?
He has no BL.
As per petitioner, his BEd degree is out of campus, off campus. So as per government order, is not his BEd degree.
But why haven't you filed your affidavit? If you have a point that his BEd degree, in spite of there being that it should not be considered because of some reasons, by some notification, you have to put those on record by way of an affidavit. You have not filed affidavit.
They have to file, my lord. NCT is supposed to.
NCT, where is NCT?
NCT, they have to take it time being after some time.
Are you there with Alam?
No, he is coming. He is from another court.
He is in lack.
Not wait for him indefinitely.
If you could,
We grant some time. File the affidavit. And NCT also produce the record. Where is the document by which you say
yes,
that NCT is not aggrieved? Page
page, my lord, page 30, 23,
2-3.
type copy 22.
Yes.
NCT has given recognition to the, my lord, degrees
Agreed.
offered by the distance education mode by IGNOU.
Yes. What do you say about this, Mr. Ali?
Yes,
Page 22. What do you say about this? Page 22. Mr. Alam,
My apartment.
you file your affidavit or come up with instructions. Do you have the instructions?
My lord,
He is relying upon a communication of yours of the year 1999.
my lord, in fact, my lord, I have received the affidavit, my lord, but till today, my lord, that was not received, my lord. They have also sent me the tracking number. Your lordship may find it. But
Affidavit has been filed.
yes, no, my lord, that has been not received by me, my lord. Since
Now that is your internal arrangement. Don't involve the court.
no, my lord, just I am informing your lordship.
Now get the affidavit in. When is the mail? Which date? Mail is of which date?
They have sent it on 22 to 2022. That is my letter also.
That from 22. No, we are not interested in looking at the letter. You write to them, it is not received. Bring the affidavit.
Okay.
It appears that none of the respondents have filed the affidavit. Also, on the request made by the learned counsel appearing for the contesting respondents, 3 weeks time is granted to file their affidavits.
Any date after 29.
Please.
My lord, your lordship may kindly may not be sick, my
Hmm?
since it will take some time, my lord. I will send them letter and they will send it, my lord. So in,
Mail takes how many minutes?
within 3 weeks, I will file it, my lord.
3 weeks you have said.
Within 3 weeks, I will file
Send a
it.
mail today. This
They
is
have
not the
received
age of
that and
sending
that means
letters.
they will mention it before your letter. After receiving the
You also file. Mr. Sharma, department also instruction at least. Mr. Borbuya,
obligement.
none of you were there. Your response?
Earlier, I was the president, but now the term of the new president has come. And as per instruction, my
You
knowledge
are
is
party by name or what?
yes, sir.
You are for Abdul Kalam.
Kalam.
He is not no longer the president.
No longer is the president. So it may take up to PM.
And what about the others? You appear for whom? 21. Item number 20. You're for R5, you're correct. R5. R5 is a party by name.
Yes.
He is no longer there. Will you ask your client to have his get instructions from your client? Are you alleging malafide against response number 5? Are you alleging malafide against the response number 5?
Yes, but if the new committee has been formed, then we have to give the new president.
No, we are not on that. Why have you made the response number 5 party by name? Are you alleging any malafide personal bias against the response number 5?
No, Lordship.
Then you could have made the party as simply the president of the committee. Whoever would have come will step into the shoes. Once you give the name, you are making somebody individually a party by person. And if he's not in the sin, he will simply say that I am not longer the president. You took instructions from your client. Okay. If you want the present president to be implemented by name, you can take instructions. Or if you want, you can strike off the name of Abdul Kalam. He'll be only the president. He'll also be free. Okay.
Okay, may be allowed to file an IA.
No, you take instruction first. What is the nature of your grievance? Is it required for the president to be made party by name? If it is not required, you can have simply the president as a party. It appears that the response number 5, who is represented by Sri F. U. Borbia, that council has been made party by name. The Learned Council, however, submits that his client is no longer the president of the school managing committee as the term has expired. Your ghost, you said? The name?
Yunanda.
Sorry, you're not on MSU Nanda Learned Council appearing for or appearing on instruction of PSC because Learned Council for the petition, however submit that she may be given some time to take instructions regarding the aforesaid aspect of the matter. Please after 3 weeks.
My Lordship, can be taken up on Wednesday. We will file. In the meantime, we will confirm it from our client. And if possible, then we will complete.
In 3 weeks, by Wednesday, you can file an IA.
No, Lordship. At least by Friday or.
No, you take instruction. If IA needs to be filed, you are giving adequate time. 2 weeks.
Lordship, any date may be.
Actually, okay. List on. On 14th of June. Why don't you sign the wakalatnama? Your name should be there. Every time we need to ask your name. Senior doesn't allow you to sign wakalatnama.
Lordship, when this matter was there,
You are not a lawyer.
may I be allowed to?
Not now. You are not a lawyer then. This will amount to regularizing an illegal process. Which will not.
Sorry, motion matter wrongly listed 2000.
We'll have it for motion.
Lordship, two interim orders, my lord, have violated by the concept of case 50
Page
Page 14.
14.
The operative portion, page 16.
Paragraph
My lord,
14.
operative portion, page 15. My lord, it is the order dated 17/3/2023. Last line, till the next date, no coercive action be taken by the respondent against the petition. And the date was fixed on 22/03/2023. Now, next order, my lord, page 16, it starts from page 16.
Mm.
Operative portion, page 17.
Mm.
22/3/2023. Here, my lord, last parameter.
Mm.
In the meantime, the interim order passed on 17/3/2023, thereby directing the respondent not to take any coercive measure against the petitioner shall continue till then.
Mm.
My lord, it was fixed on 12/4/2023. And on 12/4/2023, the matter was disposed of. My lord, setting aside the impugn order. The impugn order is that, my lord, petitioner was transferred to one school to another school. That is page 13. Now, my lord, what happened, my lord, after the interim order, so the honorable court directed not to take any court measure. My lord, the contemptor has stopped my salary. And my lord, on my lord, page 25, on 6/4/2023, my lord, a show cause notice was issued against me. So, my lord, already I have been penalized. Even after that, my lord,
Analyzed by
penalized by the contemptor by transferring me from one school to another. That was the penalty, my lord. Because of a my lord, public complaint, my lord.
transfer is a penalty.
As a penalty, my lord, it was imposed on me. My lord. Page, my lord, 16, page 13. And it was subsequently, my lord, set aside. Page 13.
1-3.
1. And on the same allegation, my lord, page 25, the focus notice.
So where do you get from where you submitted transfer is a penalty?
It is their affidavit also, my lord.
And this transfer has been interfered by this court.
Lord,
Thereafter, you say that there is a violation by issuance of so call.
it was the focus and stoppage of salary because there was an interim order. But
How are these in contempt of court?
because lordship, the court directed not to take any coercive measure. And I
Is
challenged the
initiation of a departmental proceeding coercive measure?
departmental proceeding was not initiated.
So this so-called notice is initiation of a proceeding.
But my lord, my salary part also, my lord.
Salary part is an independent cause of action. How is it a contempt? What is a contempt?
My lord, court says no coercive measure.
What is
My
a
lord,
contempt?
But
Court says no coercive measure for time indefinite.
the stoppage of salary also, my lord.
It can be a cause of action. How can it be a contempt? Contempt is willful and deliberate disobedience upon court order.
Well, I'll go for a treat.
You withdraw this. Heard three. M. Adi learned counsel for the petitioner who alleges, who in this petition alleges that there has been violation of two orders of this court, wherein two orders of the court, namely dated 17/3/2023 and 22/3/2023, passed in WPC 1221/2023. Full stop. An order of transfer was the subject matter of dispute in the state writ petition. Full stop. It also appears that the writ petition was finally disposed of by an order dated 12/4/2023. Full stop. The petitioner alleges that salaries have not been paid to him, and further that by an order dated 6/4/2023, he has been issued a show cause notice to reply to 3 numbers of charges. The aforesaid action, in the opinion of this court, cannot be said to be an willful and deliberate disobedience of any orders of this court. Though, though the same may constitute an independent cause of action to be espoused in the proper manner. In that view of the matter, under those circumstances, the learned counsel submits that he may be allowed to withdraw this application with liberty to make a proper challenge. And accordingly dismissed on withdrawal with liberty. Traffic is not possible. 29. What's the matter? Who's there? Who's the senior? You have not filed your affidavit. A prayer for adjournment has been made on behalf of the IHIK Learned Council for the petition. On the other hand, no, they are making a prayer for adjournment. On the other hand, Riyaz Das, Standing Council, Secretary Education Department, Higher Education Department, pays for and is granted 3 weeks time to file the affidavit of opposition. Please after 3 weeks. Yes, next. Doctor.
May I please get that? My lord, the petitioner challenged the my lord appointment of the my lord.
Pleadings are exchanged, have been exchanged. Here for whom? Private respondent. Who is for the department? Affidavit file.
Meeting completed.
What is the issue involved?
Issue, my lord, regarding the appointment of the president of the my lord assembly, school management development committee, my lord. The petitioner is outsider from the district. This is the main
petitioner.
No, sorry, respondent is the outsider, my lord.
And who are you?
I am the my lord local person, my lord.
You had also contended to be the.
Yes, yes. My name was forwarded, but he was selected.
You are an outsider.
There is no specific guideline regarding in this regard, one direction was made from to clarify that order is the lordship 3/6/2020.
Okay, then.
Then lordship respondent number 4 has filed an affidavit with IS, and I have also filed an ITI affidavit. Then in reply, the IS there is no car as per guideline. My house only 800 meters far from the school.
Oh, less than a kilometer.
Less than 1 kilometer.
Yes, sir. Well, Kukrada district, and the school belongs to the Dhubri district.
Yes, sir. The school is situated here in the Dhubri district, and my house is
Kukrada and Dhubri are adjacent.
But
Yes, sir.
He may be in the borders.
Well, kindly see the page 27 guideline.
He is within 1 kilometer.
My lord. Same IS, my lord, in an RTI reply, said that the person from the outside district cannot be met.
Outside district? Where? Page?
My lord, in my edition, in my reply, page my lord 95.
Okay, we'll examine this issue. When was it constituted?
My lord, it was constituted on my lord 29/3/2022, my lord.
29th of March 2022. For how many years? 4 years? How many years?
Not 5 years.
5 years. Okay, we'll have it for disposal. The issue involved the appointment of the private respondent number 6 as the president of the school managing committee of the which school?
FA Memorial. FA
Of-
Memorial
Of the FA Memorial High School
High School.
in the district of Dhubri.
My lord.
The principal ground of challenge
Well.
is that the respondent number 6 belongs to another district,
Well.
namely Kokrajhar.
Well.
And the guidelines prescribe that person from another district
Well.
cannot be appointed as the president. That is his submission. Have we passed any orders? Person from another district is not eligible to be appointed as president. Full stop. On the other hand, your name. On the other hand, the version of the respondent number 6 is that that there is no such bar, and in fact, a clarification has been given by the inspector of schools. Full stop. It is otherwise also submitted that though the respondent number 6 belongs to another district, comma, the distance from the school is hardly 800 meters. Full stop, para. The department has also filed the affidavit. Full stop, para. In that view of the matter, list this case for admission hearing. When? In the week commencing on 22nd of June.
Well.
Thursday.
Interim order may kindly put.
Para. What is the interim order?
Interim order, my lord, not to act, my lord.
The school is without a president now, committee.
Yes, your lord.
What are you gaining? You have not come for stay vacating. You are also happy.
Only for 2 days. Only for
Okay, interim order passed early to continue till the next date of it. Yes, next.
Only oblige, your lord.
Next.
He is a medical student, my lord. He took admission in 2009. And thereafter, my lord, due to various illness, my lord, he could not attend classes. Ultimately, my lord, 2019, he wrote a letter at page 27.
Oh, yes, where is health?
They are supposed to inform.
Health. And Sangodev University of Health Sciences. Who is there? B. Gogoi. Then what had happened?
Your lordship directly directed the respondents to provide what is the position of the seat for 2020.
No, he was admitted as a student.
Yes.
Then he fell ill.
He fell ill for a very long time. Initially, accident, then thereafter psychological problem, and ultimately this certificate I have given.
Now he is okay.
Now he is okay. He is intending to enter because the rule doesn't prohibit. I have seen some laws where persons are in jail for last 9 years, 10 years. They got they also could admit could complete the MBBS course. So there is no bar for that 2015. There is some bar within 10 years one has to complete a thing. But 2007 rule doesn't. There is no bar that within particular time one has to complete the MBBS course. So therefore, the court directed the authorities to provide last order, I think. Shall apprise the court the total number of seats of MBBS course in the government college of the state for the year 23-24, I think. But what I propose, subject to what your lordship say, my lord, he is a boy, and the matter is hanging for a very long time. So your lordship may direct the respondent authorities to consider my representation and take a final view of the matter. That will at least, and here the boy also, my lord. So the boy is passing a very hard time.
Yes, medical Health and
Education, National Medical Commission.
health.
Phone number
Name.
7.
So those names do not know.
And number division.
Yes, health and medical education. Me go with. Chaliha.
So I'll wait for some time and let it come. I'll find out the-
Somebody should be here at least to mention.
Yes. HTML Medical Commission, I think they are the authority as per Dr. Bora and Mr. Bora. Yes,
And who is for the National Medical Commission?
Mr. Bora. Oh, his name is not
Who?
Mr. Bora.
Bora.
Anshuman Bora. Huh? His name is not.
Has he appeared?
He appeared last occasion. They're coming. Like his representation, which was filed by the Guwahati University, said we have no document in regard to admission of the petitioner, my lord, because he did not appear in any exam. All the documents are with the authority.
Good person.
May result. And this writ petition.
Yes, secondary education. No, school education. Where is the record?
60 was okay.
Mr. Sistiani.
Record repeats that the school authority headmaster has been a resolution has sent the name of the for the post of president notice.
DC recommended.
First officer resolution of the school has recommended the the petitioner as a serial number 1 for the president notice of the particular school and a private and serial number 2. That was forwarded by the inspector of the school notice. The petitioner has a serial number 1 and a private and serial number 2. And as per the 21 notification lawsuit, the deputy commissioner with the approval of the guardian minister lawsuit. Now they have decided lawsuit. The private husband as president lawsuit in place of the petitioner. That is my record.
Now, as per the new notification, this election would be done by the deputy commissioner with approval of the guardian minister.
Yes.
That is the notification holding the field.
Yes.
The selection by the people, those are not required.
That resolution will be taken. That will be forwarded by the inspector.
The ultimate selection will be done by the deputy commissioner. Now, here, what is the case? Your
Deputy commissioner has recommended it. The guardian minister did not give the approval. Instead, gave the approval for the private respondent, who is now working in the power department at Chilchar. And the school is at Harapur, opposite to the house of the petitioner. So, the headmaster has also given an affidavit saying that this is not practical because as per the guidelines of the committee, the person has to go and inspect the school. And
where have you stated that respondent number 6 is not normally stationed at
my lord, in the yes, writ petition content.
Page 15, para 16 was.
If it has been managed by the headmaster, in the pleading is also there.
R6 has appeared. Respondent 6 has appeared.
No.
Neither ready card nor The term is 5 years, isn't it?
Yes, ma'am.
Yes, yes.
The consideration on which you are assailing, I think that would require some that factor is a relevant factor. If the person is normally not patient, he may not be able, but without his participation, because it's not the case, it has been served and he has not appeared. The note is that neither ID card nor unserved notice. We will do one thing. Let this matter go to the Lozima court. Are you willing to go for dusty service?
Yes.
Go for dusty then and file an affidavit.
And
Third,
immediately then.
third, 3 BT for the senior counsel for the petitioner who is aggrieved by the action of the authorities in selecting, in the matter of selection of the president, selection and appointment of the president of the school management and development committee of the Dharapur Higher Secondary School. Full stop. It is the case of the petitioner that though as per the notification dated 27/10/2021 holding the field, the deputy commissioner had selected the petitioner for the post of the president, the approval was not given by the responsible number 4 guardian minister without any reason, and rather approved the name of the responsible number 6, full stop. The senior counsel, by referring to the averment made in paragraph 16, is it?
Well, an affidavit is filed by the headmasters.
No, you have also said in paragraph 16.
Yes.
That the state responsible 6 is an employee
Of Assam
of
Power
the
District.
APDCL and is presently posted at Silchar. The aforesaid fact would be a relevant factor which would have a bearing in the adjudication of the case. However, office note dated 16/3/2023 reflects that neither AD card nor unserved notice has been received by the section towards service of notice upon the response number.
Response number 6, ma'am.
No.
Private respondent is number 6, madam.
No. You're not required. He is served.
Yes, sir.
The AD card has been received by from president. The 6 has been served.
Well, then the issue is simple. Well, the
4
deputy
has not been served. 4. Who is 4?
who is the guardian minister?
4, I think we will refer it to the Lozima. Pass of Dim service. Guardian minister may not be interested to contest in his name.
Yes.
6, if 6 is served, matter ends there.
Yes.
By the office, so far as the response number 4 is concerned. However, the earlier office note dated 27/2/2023. However, the order dated 27/2/2023 passed by the learned Lozima Court reflects that service upon the respondent numbers 5 and 6 is deemed to be complete. Para. In that view of the matter, let this case be listed again before the learned Lozima Court to pass appropriate orders on deemed service upon the response number 4, whereafter the matter is listed, is directed to be listed before this court.
May I pay for any specific thing?
List list within a period of 4 weeks from today. This is within we'll pass final orders. If 6 is not before us, we'll pass orders.
Well, may I pay it on 28th of June?
We do not know when Lajima is sitting. We say within 4 weeks. It may be before that also. Mr. Chaudhary, what is this? Promotion.
Yeah, yet to receive instruction box. Kindly grant us 2 weeks.
Well, come up for the first time after 22.
Yes, after the notice.
It appears that to notice. No, don't write it appears. Right. Though notices was issued on 28/8/2022, it appears that the matter has not been listed after that. Full para.
It was listed, my lord. It did not raise my twice, my lord.
Until there is an order which cannot say, was not listed, was not listed for was not listed for consideration. There, para. 3. SMTC Standing Council, Secondary Education. Praise for and is granted 4 weeks time to obtain the instructions plus file affidavit in opposition. The Learned Counsel for the petition, however, submit that the matter in fact was listed, which did not reach in the reach for consideration.
Here the application of the students, my lord, 2 students, and issue of post transfer certificate, my lord. Here whatever, my
Here
lord,
for whom?
Principal.
they have filed affidavit and we have given the reply. And in their affidavit, the cat is out of bag. Here whatever, my lord, there was a function.
Which college?
Is my lord the
Anpur College.
Haji Anfar Ali College.
yes, Hojai.
It Hojai.
Yes.
You say that there was no inquiry before such expulsion.
No,
You
inquiry
alle-
is that internal, they,
That is it. You are not given opportunity.
no, that is what I brought the decision of the 1972 of this court judgment by his lordship Goswami.
Yes. What do you say? Did you give
Just
opportunity?
because the student, they used to not.
So what the procedure is concerned, following due procedure, giving the complaint from the student, all students for the ministry here, accordingly, my lord, taken minutes and accordingly FIR.
What is the procedure you are following?
An inquiry, an inquiry committee has been formed. I have annexed in the
Procedure is laid down where?
I have annexed here.
Tell us where. What is the procedure? You have filed affidavit.
Yes,
Yes,
they
my
will.
lord.
Page. Is it 43?
Page, yes,
Annexure 2.
page, annexure 4, kindly, page 15, my lord, of my application.
Annexure 4. Is the notice, I think.
Yes, my lord. The inquiry committee has been
No,
formed.
no, we are not on that. What procedure are you following by which you have held the inquiry?
My lord, as per minutes also here, my lord.
Again, you are not on the minutes. What regulation? What law? Are you governed by some any law or regulation?
My lord, regarding the school, my lord, college, for this problem, my lord, basing upon the complaint, we have forwarded the complaint up to the police, my lord, that's all, and according to the
See, you have taken an adverse action against somebody. If there is a set of rules, you tell us this is the set of rules you are following. If there is no set of rules, then you have to abide by the principles of natural justice. if you take an adverse action against anybody, give him an opportunity. You have the power to pass an order of expulsion. But before that, did you give an opportunity to the aggrieved party?
My lord, they have the option, my lord, for the college authority, university, my lord, they can apply there, my lord, for this, my lord. I have no objection if the university grants them, my lord.
No, see, they are aggrieved by certain actions taken by you. Before taking the action, was it preceded by an opportunity, reasonable opportunity to the aggrieved person? See, we are not commenting anything on the marriage.
Yes.
There may be allegations may be very serious. In fact, the allegations are serious.
But
But
inspection, my lord, for 1 day.
on 2 points. First, is there any set of regulation, or are you following any laid down regulations or any other which you have adopted for matters of this kind? Definitely, this is not the first instance of the incident of this kind. All education institutions may have this kind of situation. How do they deal with? There would be a set of rules which you might have applied, or you might have your own set of rules. If there are no set of rules, have you given the opportunity? Have you complied with the principles of respect on these 2 points? What are the allegations? Let us see the allegation.
My lord, what happened? Let me explain
Let us read the allegation.
Allegation, my lord.
Allegations are very serious.
Page 17, my lord.
Yes.
So they issued the one show cause. Page 17 of the institution.
Yes.
This is the, my lord. And there were, my lord, 3 students were issued show cause. Now only 2 have been proceeded with. With reference to the subject study above, this is to inform you that you have been suspended from the college for doing indecent, unethical, and immoral acts. The video is with me, my lord, with my junior. They were dancing after the college function was over, and one was singing, one was beating the drum, one was clapping, and was dancing. There was no.
Now, what about the allegation by a girl student?
Then, my lord, on this account, they issued the token suspended us, and we are also debarred from entering the college campus immediately. First is that. Then, my lord, came the my lord, page 18. We explained. In the evening, it was circulated in the Instagram.
Now, what is the immoral activity?
We danced and sang and clapped.
No,
And
there will be something else.
no, video is there, my lord. Live video is there.
What is the allegation?
We have not said anything. What is in indecent?
In my affidavit, I have the next matter. Some statement of the girls, what they have done. Actually.
Only 7.
Where page?
Page 1 of annexure 6, page 24, matter.
Annexure 6.
Page 24, matter.
What about annexure 5?
Annexure 5. That is the statement of the some girls, my lord, or second actually in that day.
Not there even there. Nobody was there except the 5 students.
Where annexure 6? Where is annexure 6? Let us see. Yes, annexure 6. Who has written this? Who has written this?
They are the student, my lord. Janara Begum, Marufa Begum, Joseph Begum.
Girl student?
Yes, girl.
Yes, let us read this. Allegations are there, but where is the immoral
And
activity?
this is not the mallet that video of
This
the
we are
bank.
not
This
in
is
any
outside the
manner,
college.
in any manner we are endorsing this kind of behavior, but it is not that kind which may amount to extreme penalty of expulsion. In all colleges, these things have appeared.
My lord, may I show a lot in NXS 6 is 25.
There is no allegation of serious nature by the girl students
And
of
this is
any
not
harassment.
driver, bus fare, these things are not there.
Even after the information, they are threatening the student, those who are giving statement.
No, those we are not saying those are not not serious offences. Those are serious offences, but not to the extent that you go for expulsion. You can take other rakas in the school, rivalry between two students. Okay, you passport recorded. Third, Sri R.P. Sharma, that is Senior Counsel for the petitioner. I don't think I have much wrote. Sri A.Y. Chaudhary, Lieutenant Counsel for Respondent number 3, 4, and 5. Submit that affidavit in opposition has been filed. Full stop. Since it is not discernible from the affidavit as to what rules were followed before passing the impugned order by which the petitioners were expelled from the college, Sri Chaudhary, the learned counsel, prays for and is granted 2 weeks time to obtain instructions.
Can you be started by?
Wait, 2 weeks time to obtain instructions in that regard. Full stop. This shared instructions is also necessary because as it reveals that no proper opportunity was afforded to the petitioner before passing of the impugned order of expulsion. Sarah, list on, tell us the date of your convenience, Sharma.
15 days after.
Today is 29th. We'll have it on 16th of June. 16th June.
Well, one interesting thing may I show just one cloud. Okay. Will also kindly come to page 13 of
Of
the
your-
affidavit.
Their affidavit.
Yeah.
There's a pen mistake there.
No, no, just wait. Don't print it there.
13.
13, yes, 13, no? No, sorry, 12, in 3. This letter was, and the same girl system, same 7 girl system being used by the principal every time. Not out of 800 students. Date you are also going to see, respective principal Hazim Anfar Ali College, 15/10/2022. It was written 23, but you were corrected 22.
No.
Is a excuse. Then while kindly come to page vernacular, page 14.
Yes.
When you was received, 10/7/2022. Dated 15/10. And it was backdated, received 10/7/2022. Vernacular one. So everything, only 7 girls system they picked up out of 800. And they are bringing some allegation outside the incident.
No, even one girl's allegation would be enough, Mr. Sharma.
No,
We are
one
not-
is enough, but
But
no,
your the other
no,
thing is
one
that
thing, my lord, that allegation must be related to that event where they are dancing and
no, the other submission by you will have to be considered because this application of 1510, how can it be received on in July?
yes.
This is
Just
that is on putting this date, my lord, connected that first index, it was wrongly put.
We are not on the index. Come to the vernacular at page.
That has been put there, my lord, wrongly, my lord. Barely submitted, this is wrongly.
In the vernacular also.
The other way in the left side, my lord, kindly see the original date for senior friend submission, my lord, that is visible there.
Then
So,
it is
this is wrongly put.
rather interesting one in the page 13 itself, 10/1/2022. The 3 dates.
10/1/2022 and 15/10/2022 and 10/7/2022.
Otherwise, my lord, there was a, my lord, considering this
Same student.
student future, my lord. This
No.
consecutive period, my lord, as per their procedure, my lord, they are not allowed to sit in the examination. Their examination date is over already.
No, our entire
Okay,
case is
you,
what you are
yes,
talking
yes.
about, date of
You get
one
the
loss.
instructions, okay? Yes, next.
Here, my lord. Shortly, if I may say, my lord, he took admission in a medical college in 2009. The lordship will kindly say page 14.
Yes.
Lordship, at the outset, before my learned senior colleague starts, at the outset in this matter, the National Medical Commission was not a part.
No, we had made it 7, I think.
On the previous date, Lordship, yes, on the previous date, we have been included.
Yes.
And copies have been served upon me, my lord, and I have sought for the instruction. Probably awaited in a day, 2 days or 3 days, my lord. That is the status on our part. And if it pleases your lordship, then my name may be reflected in the for
You are appearing for respondent 7.
Respondent 7, my lord.
Who is to take a decision here? National Commission or you? Both of you. You have got instructions. You have already appeared. 6 and 7 is written.
What yes, sir, let them take instruction. Let them do, otherwise, let them take a final call in the matter, considering my representation.
How to repeat the learned counsel, senior counsel for the petitioner who submits that no response has been filed by any of the respondents till now. However, both Sri V. Gogoi, learned counsel for the respondent numbers 5 and 6. 5 and 6.
5 and 6.
5 and 6. Srimanta Sankar and academic registrar. 5 and 6. As well as
Number 7.
your Upamanyu.
No, my lord, I am D.K. Boyter.
Oh, sorry, D.K. Buddha. Learned counsel for the respondent number 7. Submit that instructions have been sought for and are awaited. How much time? 3 weeks time?
3 weeks to file 22. My lord, I understand the ballot. Monday next, my lord, let them take an instruction.
Next week, my lord, any day.
Awaited. In that view of the matter, release this case on we'll have it on 9th of June.
My lord, they will take instruction as regard, my lord, subject to what your lordship has said. As regard who is the authority to take a final call in that.
Even that aspect, 9th of raised it to reflect the name of Sri D.K. Buddha as counsel for respondent number 7 in the conflict.
They will take instruction who is the authority to take a final call.
That will come.
So they are.
Deeply obliged, my lord.
Lord, in this case, no one has filed any affidavit. And so far as 4 and 5, so enter here and by filing for. Now, my lord, matter relates for my lord during COVID-19, when the examination was conducted online.
even though my lord, the Tharupete College, the principal collected illegally the student fees. And therefore, my lord, one representation was made addressed to the respondent number 3, Deputy Commissioner, paying to release the illegal collected fees. That has not been yet disposed of, my lord. And
Yes, who's appearing? Just a
The section of the Deputy Commissioner. There is no sort of excessive by the college of
just a minute, just a minute. Right. Huh? It's on, it's on. It's on. What is it? C bro, B bro. No, delete number will. Delete it. Very good. Itu kita take a video. Yes, any instructions by you?
my lord, they have presenting the notification letter, page number 37.
4 and 5 has appeared.
No, my
4 and 5 has appeared, yes.
shared instruction will be required. Because
Who's appeared for 4 and 5? M. Rahman, J.U. Ahmed. Names are shown in the cause list. M. Rahman, J.U. Ahmed. The private respondents 4 and 5 do have appeared through learned counsel whose names appear in the cause list, comma, none is present for the state respondents. Full stop, para. In the interest of justice, are you there for 4 and 5? No. For the interest of justice, let this matter to be listed on Wednesday next.
Lordship, in the meantime, my would submission.
Day after tomorrow. And if you know them personally, ask them to visit.
I love.
Maybe. In this case, my lord, the affidavit of the respondent will be required. Let me file it.
Secondary education. On the prayer of Sri U. Sharma, Learned Standing Council, Secondary Education Department, matters still adjourned by 3 weeks to enable him to obtain the instructor.
Any day after my lord vacation.
3 weeks, let us see thereafter.
Problem.
Next. You have received instructions.
My lord, in this case, my lord, this is a case of provincialization of the gate 3 and gate 4, my lord. Out of the 194, 90 are left out. May I submit one pair, my lord? Tendency of this rule, there is no bar to appoint the petition.
MS Tutia, Learned Standing Council, BTC,
I am appearing on behalf of the
Learned Council, appearing on instruction of Sri P. Nayak for the BTC, prays for some more time to obtain the instructions.
we have already
Submit that instructions have been received, based upon which an affidavit could be filed, for which some time has been paid for. MS Kiri, Learned Counsel for the petitioners, prays that an observation be made that pendency shall not be a bar for consideration of the cases of the petitioner. Full stop, para. List after 3 weeks.
15, my lord, June.
List after 3 weeks to enable filing of affidavit in opposition by the BTC respondent. Full stop, para. Pendency shall not be a bar for consideration of the cases of the petitioner if they are otherwise entitled for such consideration as part of
Highly
if they are otherwise entitled in law.
Okay. My lord, I am going to write counter effective method during the court during the court
National Commission of Teachers Council of NCT.
order was. My lord, definitely after on the earlier occasion it was said.
Let him file the affidavit. I alum and Training Council NCTE submits that instructions have been received, based upon which he prays for and is granted 3 weeks time to file.
That is delayed for consideration of the interim period because the university has issued the admission notice. Now here the whole case is, my lord, in 2019, my lord, they have cancelled withdrawn the recognition on the ground that the approved faculty list was not there. On appeal, they found that particular list is available.
How soon can you file?
This way, my lord. It's steady, my lord. Today I am going to file.
Or today he's going to file?
Yes, my lord.
Let him file. We'll have it next week.
On Friday, because the admission notice.
Next Monday.
Monday.
People will pull with you. No. The ILM Training Council NCT submits that based upon the instructions received, the affidavit is ready and will be filed shortly. Full stop, Sarah. List on Monday. On 5th of June, along with the affidavit in opposition that may be filed in the meantime.
If he starts today, if my lord
He'll
requires
seek
the response. Now, my yes, I'll file the response.
Yes. Yes. For the R. Mazumdar, you're a Training Council. Training Council, Liberagan University Press. Visa Secure Training Council for the petitioner and R.
Next legal lordship. This is that matter, my lord, pertaining to the screening committee, which was constituted by the
For provincialization.
no, this is for regulation of the this is OPB, for correction of a status from not working to working.
Affidavit filed.
Not only my lord, respondent number
1 and 2 have filed affidavit. Would like to reply to them?
No, my lord, actually not necessary. My lord.
You tell us, Mr. Mazumdar will be appearing.
Yes, no, I am appearing for the education department. So that page 71.
We can have it for admission.
We can hear it.
Next Tuesday.
They have to file their affidavit because our screening committee did not find their names there. And those who were found, they were not found to be
Ms.
eligible.
Bora is for VTC. You find affidavit. Matter of which year? 18.
18 matter.
18 matter. We give you 2 weeks time maximum. No affidavit in opposition has been filed by respondent numbers 1 and 2, comma. The PTC authorities have not filed the affidavit. Full stop. 3 Bora, as Bora Training Council PTC, accordingly placed for some time. Full stop. However, considering that this writ petition is pending since the year 2018, comma, this court has reluctantly granted 2 weeks time for filing of such affidavit by the victim. Please, Dr. Trui. Yes, Mullah. Yes.
First is matter relating to the correction of date of birth service record. Petitioner He appeared in the SSLC examination in the year of 1984, Lordship. And he passed out. And in the admit card and subsequent matriculation certificate, his date of birth wrongly recorded as 31.
Just yes, you passed your matriculation when?
1984, Lordship.
84 HSLC.
Yes, Lordship.
Then
In the admit card and other certificate, my date of birth was wrongly recorded at 31/1964 instead of my correct date of birth 31/1968.
this is incorrect.
Yes, sir.
3164 is incorrect.
Yes. 64 is incorrect. 68 is correct.
1968 is to the pen.
Thereafter,
Okay.
Lordship, 21st July 1999, I have made an application for the headmaster to the secretary Seva for the correction of my date of birth. Lordship. Annexure 9, Annexure 1, page 9, Lordship. This is my application. Thereafter, another application I have made to the Secretary Board of Secondary Education for the headmaster.
When?
Annexure 2, page 10. Lordship. Page 10, Annexure 2. Lordship.
Date?
It was date 10/12/2014. Lordship.
14.
Thereafter, Lordship, Inspector of School, Karimganj, issued a letter to the Secretary Board of Secondary Education to take necessary action in this regard. Lordship, Inspector of School very record a call from the headmaster, and he find out this is correct and genuine. Then Inspector wrote a letter to the Seva, Secretary Seva.
When?
It was on Lordship dated 16/12/2014. Annexure 11, page 3. Sorry, Annexure 3, page 11. Lordship, now page 12, Annexure 4. Seva corrected my date of birth.
Page 12.
Page 12, yes. Annexure 4.
When was it? When
It was corrected on Lordship 26/5/2015. 5/2015. Lordship.
Corrected.
Yes, corrected by Seva authority. Lordship.
It was made 31/1968.
Yes. Then, Lordship, kindly peruse annexure. Director, page 21, Lordship. I have made an application before the Director, Higher Education Department, for correction of date of birth in my service record. Page 21, Annexure 12.
Date?
It was dated, Lordship, 23/6/2015.
26?
2015.
2026?
23/6/2015.
You applied it for whom?
Director.
Of?
Higher Education Assam.
For correction in service record.
Yes, sir.
So you are working as what?
I am working as LDA in the Nobin Chandra College, Bodorpur. Law Division Assistant, Bodorpur.
College.
Then page 23, Annexure 14, Lordship. I'd like to read, Lordship, relevant portion.
Yes.
With reference to your letter on the subject cited above, I am directed to state that date of birth can be recorded within 2 years of exam and not beyond, that is after 20 years. In view of the above, original certificate of SSLC examination and original certificate of Abdul Hakim, LD assistant of your college are returned. Lordship, Director Higher Education, Lordship, rejected my application on the ground that I have made application. I have not made application within the 2 years from the date of examination, Lordship. Lordship, but law permits me, Lordship, as per SR 8C, SR 8C, may I read, Lordship, SR 8C.
In the meantime, Lordship, SEBA authority filed their additional affidavit, wherein they categorically stated that they have conducted inquiry and after found genuine and correct, they have corrected the date of birth of the petitioner in his matriculation document certificate. Filed this affidavit by the SEBA authority. And SEBA authority already corrected my date of birth in my every document, but higher education, director of higher education rejected my claim that I have not made application within the 2 years from the date of examination. Whereas, Lordship, SR 8C, commissioner and head. Lordship, comment portion is also related.
Have you quoted anywhere? Have you quoted this provision?
Lordship, SR 8(6), Lordship. In my book, Lordship, page number 29.
SR 8.
8C.
What is there?
Commissioner and heads of departments may alter the recorded date of birth.
Yes.
Date of birth in the case of non-gazetted government servants, provided they are satisfied after inquiry that previous date was incorrect. Okay. Comment portion. The provisions of SR 8C contemplate that if there is any dispute regarding the date of birth recorded in the service book and there is some prima facie evidence, the competent authority should hold an inquiry in the matter for a decision, and in such an inquiry, the principles of national justice should be followed, as held in Mohan Chandra Das versus Director of State Transport Corporation AIR 1969 and N259. If no such inquiry, it is found that the date of birth recorded in the service book is not correct, and the later date of birth as alleged by the employee is correct, the retirement of such employee on superannuation on the basis of date of birth recorded in the service book would certainly amount to punishment, as laid down by the Supreme Court in the Purushottam Lal Dhingra versus Union of India.
We are not interested in the comments.
Yes, Lordship. In the main portion is that, Lordship, if authority conducted fair inquiry and they found the claim of the petitioner is genuine and correct, then they can correct the service book in respect of date of birth. This is permitted by the SR 8C. Lordship, I would like to place one judgment of this honorable court, Lordship, WPC 5255/2007. Lordship, paragraph 7 and 12, most important, Lordship, paragraph 7, I'd like to read first.
Yes.
Yes, Lordship. Mr. P. Kakuti, the learned counsel refers to the speaking order to project that there was no consideration of the many documents produced by the petitioner, and in fact, the petitioner's representation was rejected only on two grounds. That is, the prayer for correction was made beyond 3 years from the date of the SSLC exam, and the admitter issued by the school was found to be manipulated. Lordship, then paragraph 12. Lordship. May I read, Lordship? The petitioner's plea for age correction in the SSLC pass certificate was ordered to be considered on merit by this court in the two earlier cases. And in fact, in the WPC number 5351/2006, the court specifically directed to consider consideration on merit without factoring the lateness of the request made after expiry of 3 years from the date of examination. Therefore, as long as the court's order dated 19/2/2007 in the WPC number 5351/2006 remains undisturbed, the petitioners.
Okay. What do you say?
Yes, sir.
Siba, now are you disputing the fact that on 26/5/15 you had corrected the date of you have correct, not disputing that fact? And if you have corrected, you are the authority. Can the director raise an issue in this case, in the facts and circumstances of this case, that regarding the period of correction?
And the particular provided by the
No, we are not into the justification. We have asked you that whether you are admitting to the correction made. You have said yes.
Yes,
I don't think you have any other rule. Yes, the director. When are you retiring? One second. What is the
I will retire within 3 to 5 months, Lordship, but I have made this application 2014.
Yes.
What the type of filing of the repeated murder? Its age was 1 year as per its open hearing. However, there are several so it cannot seek for change of his date of birth at the fact date of failure. So the order shown here it is allowed is of 2070 and the petition is filed in 90. But whether some people would arise, but whether their practice on the part of the petitioner entitle him to correct his date of birth at the fact date for this service period.
No, he's still in service, isn't he?
This is a service period, not
Now, is it a fair? Is it? Can this be termed as a fag-end? Repetition itself was filed in 17. 19.
Yes, the issue order was
17.
17.
That means he had applied today. This is which year? 2023. He had applied at least 6 years before the date of birth.
His date of birth was
That is the date of superannuation. He's still in service. Normally, what is the standard? 5 years. What is the standard? How many years before the date of the superannuation one should apply? Now here it is the date may not be the sole factor because he is supported by a corrected SEBA certificate of 2015, which the SEBA is supporting. Council is also saying yes, this certificate we are not having any issue.
Right now, SEPA has corrected,
No,
allowed to.
Not
Now-
wrongly, not wrongly.
no, that issue you could have raised, but you have not. Nobody has raised that issue, and they are the authority. Council on examination has said that there is no difficulty with this proposition. It's a correct certificate. Now, as a director of higher education, do you have the, and what is the ground of challenge, ground of rejection? The ground is not that he has applied for at the fag end of his career. Ground is that you cannot go for correction
Within 2 years.
if it's not done in 2 years. I think that is not within your ambit.
Is that because kind of is correction.
Mr. Das, we are aware of the general law which is to be followed. But first, here you come to the impugned order. What are the reasons cited?
Stated should have filed in 2 years.
What? The correction.
Correction.
Has it been cited that you have applied for correction at the fag end? That is not the reason. That is not the reason at all. That could have been a reason we could have examined. And that also, then the issue would have arisen whether that is at the fag end. 17 to 23. I don't think the director has this jurisdiction to reject on this ground. And he has not cited any other ground. So thus we are not on the correctness of a decision. We have to see the lawfulness. Whether it was, you may have good reasons. He may be actually born in 1964, but we have to go by the procedure.
But aware about this date of birth. He raised this question on later.
But that raised this question, but the question is not before us. That has already been answered by the authorities. SEBA, the authority has said that it is correct, his contention is correct. And nobody has challenged the decision of SEBA. Under those circumstances, can you deny the benefit? Normally, we are very strict with date of birth. We do not entertain petition. Again, anybody will come, extend my date. But this appears to be a different case, exceptional
The
case.
type of entity, sorry, that is the
Once it is corrected, it is not that he has applied for date of birth based on some horoscope or something. He has got a corrected date of birth by the main authority, SEBA.
yes,
And not accepting that on a reason that you cannot apply after 2 years by the director, that is no reason. SEBA could have rejected his prayer that you have applied after 2 years. That would have been another cause of action. SEBA has accepted.
as per my knowledge, SEBA, as per SEBA rule, my lord, apply 3 years from the date of action, but they actually allowed to correct.
Now, nobody has taken action against SEBA or nobody is aggrieved by.
That's the rule framed by SEBA, but here is statutory rule. SR 8C plus we will over the SEBA.
I think this has to be allowed. What is your name?
AK Azad.
You are not on record.
On behalf of the youth in Lordship.
you on record? Anyone on record is with you?
No, Lordship, Purnima Adhikari is not present. He has been on behalf of Chetan, I am appearing, Lordship. He is gone to Hoja.
There are four counsel. At least somebody should be there. You're appearing, we don't have any problem. You appear, but since you're not a recorded counsel, what about the other counsel, NY Konyak, Eutin?
Other counsel, I don't know what. Mr. Jiutin is Hoja. Due to his daughter's admission in Hoja.
That is okay. We don't have an issue. But somebody has to be there. You appear like this. A.K. Azad.
A.K. Azad.
Court 3 A.K. Azad. Learned counsel appearing on instruction of the Jiutin. Learned counsel for the petition. Also heard 3 Gida as the understanding counsel. Higher education. Higher education department, whereas 3 D.K. Roy, standing counsel. Deva is present for the respondent numbers 4. Respondent number. Considering the subject matter in question and the fact that the respondent number 4, Deva, has filed the affidavit from this petition, which is pending since the year 2019, is taken up for disposal at the petition stage. The fact projected is that the petitioner is serving as the lower division assistant within legality. Please have your seat at the Nobin Chandra College, Badarpur, in the district of Karimganj. His appointment relates back to 16/10/1992 of 92, initiated by the governing body of the college, whereafter his service was approved by an order dated 19/6/2009 by grant of regular scale of pay with effect from 1/5/2009. The controversy raised is with regard to the date of birth of the petition. At the outset, it will be mentioned that matters that the trend of this court in matters pertaining to correction of date of birth is a strict one, whereby such practice of applying for correction of date of birth at the fake end of the service period is discouraged. However, the facts of the incident case is somewhat different, which could be revealed by the subsequent narration. The petitioner appeared in the HSLC examination and in the admit card, on the admit card, his date of birth was recorded as 30/1/1964. which according to the petition was incorrectly done, and his actual date of birth is 30/1/1968. Full stop. The petitioner claims to have applied to the concerned authority, namely the Board of Secondary Education, within bracket SCBA, by submitting an application dated 21/1/1999. Full stop. As no action was taken, full stop, no comma, the petitioner had submitted a second application on 10/12/2014 for correction, and the said application was duly forwarded by the Inspector of Schools, Karimganj, to the SEBA by a forwarding letter dated 16/12/2014. Full stop. The SCBA, after due deliberation and examination, had corrected the date of birth on 26/5/2015, by which 2015, full stop. Accordingly, which was corrected to 30/1/1968. Full stop. Immediately after such correction, immediately after communication, immediately after receipt of such communication regarding correction, the petitioner submitted an application to the Director of Higher Education on 23/6/2015 by requesting for making consequent correction in the service record, in the service book. Full stop. The said application was kept pending for about 2 years, whereafter, by the order dated, by the impugned order dated 23/10/2017, the request was rejected with the on the ground that the correction should have been done within 2 years from the date of publication of the result. For ready reference, the the observation made in the impugned order is extracted herein below. Full stop. Page 23. Para. As would be as would be evident from the said order, the original HSLC certificate and original service book of the petitioner was accordingly returned to the college. Full stop. Para. 3. Azad, the learned counsel for the petitioner, submits that the aforesaid rejection is not sustainable in law, as the same has been done without citing any cogent reasons, full stop, by drawing the attention, by referring to SR H within bracket C. He has submitted that the head of the department may alter that power has been vested upon the head of the department to alter the recorded date of birth in the case of non-gazetted government servants
after being satisfied, on being satisfied after an inquiry that the previous date was incorrect. Full stop. He submits that the reasons cited in the impugned order do not reflect that any such satisfaction was arrived at after an inquiry, that the petition, before rejecting the said petition. Full stop. No, it would not. It is fine. He submits that the reason appearing in the impugned order do not reflect that the procedure followed in the aforesaid provision was procedure later, in the aforesaid provision was followed. Full stop. He further submits that the reason assigned is not at all germane to the consideration which is required to be made as per the prescription of law. Full stop. He accordingly submits that the aforesaid order is liable to be interfered with, more so when the date of superannuation of the petitioner is approaching, and there is about 5 months of service period. 5 months.
Sorry, not properly aware. I have informed the 5 months.
There is only some months of the service period left. Before recording the submission of, before dealing with the submission made on behalf of the department, this court deems it fit to to record in this order that the authenticity of the correction made by SEBA regarding the date of birth has not been disputed by the Senate Council of SEBA, and rather in the affidavit filed, the same has been admitted. Full stop. Thus, the Learned Training Council, Higher Education Department, while defending the impugned order, has submitted that applications for correction of date of birth are not liable to be entertained at the fag end of the service career. He submits that there are a number of judicial pronouncements to this pronouncement in this regard, as the same would lead, as the same would open a floodgate of application by unscrupulous employees who would like to get their date of superannuation extended on the issue of an incorrect date of birth recorded in the service. The rival submission made by the Learned Council for the parties have been duly considered, and the material placed before this court have been carefully examined. The issue which arises for determination is the validity and correctness, validity and the procedure adopted for passing the impugned order dated 23/10/2017. The rejection of the case of the petitioner for correction of his date of birth, as would appear
as discernible from the impugned order is not on regard of the same being applied for at the fag end of the career, but on the reason that the date of birth can be corrected within 2 years of the exam and not beyond that, that is after 20 years. The said reason in the context of the instant case would be wholly irrelevant, as the correction was done by the appropriate authority, namely STPA, which was accepted by all concerned. The correction was done in the year 2015, and only after such correction the petitioner could have applied for consequent correction of the date of birth in the service book of the petitioner. The reason assigned are, in the opinion of this court, are beyond the jurisdiction and ambit of the powers of the authority passing the order dated 23/10/2017. Though the authority was vested with the power to be satisfied by holding an inquiry, that not having been done, the impugned order with the reason assigned cannot be held to be sustainable in law. The this court has also find forth the argument made on behalf of the petition based upon SRHC, which lays down the procedure for correction, and in the instant case, the rejection not being on the ground of delay or delay in applying for such correction, in the service book, or the same being done at the fag end of the career, this court is of the opinion that the impugned order is not backed by the sanction of law. This court has also noticed that the application for correction was done at the earliest possible after the correction was done by SCPA in the record, in the admit card pertaining to the HSLC examination of the petition. And that was also prior to more than 5 years of the date of superannuation. Therefore, even assuming, and therefore, even the instance which has been thought to be argued on behalf of the department may not be correct, may not be factually correct. In view of the aforesaid discussion, this court while interfering, while holding the impugned order, while setting aside the impugned order dated 23/10/2017, directs the authorities, more particularly the response number, not 4,
No.
Two.
Response number 2, yes, sir.
to make necessary corrections in the service book of the petitioner regarding his date of birth expeditiously and in any case within an outer limit of 2 months from today, as petitioners, as it has been submitted that the petitioner is petitioner will hardly has about 5 months of service period left, if which has been reckoned from the incorrect date of birth. Full stop. Writ petition accordingly stands allowed. The petitioner may submit a certified copy of this order to the director to do the needful. Yes, what is this?
May I please illustrate?
Hmm.
Lordship, here the petitioner is a grade 4 employee at Bacteria Higher Secondary School, Hapati, and he has challenged the issue order dated 10/9/21 passed by the Special Secretary, page 69, to Special Commissioner, Secondary Education Department, rejecting his claim for regulation and his payment salary lordship, which is pending since 2004. They are availing his service till date, but not paying his salary since March 2004.
Yes, you filed your affidavit.
Yes, Lordship, and we have filed about it.
What is your stand?
Paragraph number 12, my lord.
Of your affidavit?
Yes, sir. The appointment of the community was a case of appointment without any vacancy in control, and there his appointment is illegal and inconsequent. His service cannot be regularized on the grounds and consequence of adopt service, and accordingly his case for regularization was rejected by the order.
What about the salaries? Is he working or not?
He is working.
Hmm? If he's working, you need to give the salary. Cannot utilize the service. You could have discontinued the services, which you have not done.
Lordship, his initial appointment was by the Director of Secretary Education. How can a Director of Secretary Education make an illegal appointment? And a Lordship may annex A page 25. This is the appointment letter by the Director of Secretary Education. Pursuant to a government sanction order, at post, grade 4 post was allotted to the Bacteria Higher Secondary School, the first paragraph of this. And in that post, the petitioner was appointed on 1st February 1994. Subject to discharge with the third paragraph. Subject to discharge with
This is the very crucial period, madam, 94. We know what had happened in 94. Cyclostyle copies with the date, some details being put later.
No, Lordship.
There are a series of illegal appointments.
This is not illegal appointment, Lordship. Lordship may kindly
They have said it's illegal appointment.
page,
We are on the point of the salary, Mr. Sharma. Legality of the appointment we will consider later, but can you deprive of the salary?
Yes, Lord. This is on page 28, Lordship. His service was extended till the post is filled up by regular appointment. Page 28 by the inspector of school. And Lordship, Annexure F series. This is all the communications from secretary to inspector Lordship for regulation of petitioner service against the post lying vacant. His service is not illegal. His appointment is not.
How did you enter into your service? You are saying you are emphasizing on your statement that your appointment was not illegal. How did you enter into the service? Did you face any recruitment process?
Against this sanction order, Lordship.
Did you face any recruitment? Did you participate in recruitment process?
Lordship, against this government sanction order.
That we have understood. That is for a vacancy.
Around 400 Lordship.
Where have you stated about recruitment process? But which advertisement?
Lordship, against this government sanction order, some employees were appointed by the director of secondary.
Can it be done without a public employment, without giving notice?
And most of them have been regularized.
We are examining your case, madam. Those are not before us. Can you enter into public employment without participating in a process of selection?
Lordship, it is the appointment by the director, and they have processed the authorities processed the petitioner.
You're not answering the question.
And they have been availing.
Can you envisage somebody having a government job without going for a selection process?
Lordship, it is.
Why not you? Why not me? Why you? Everybody should have been given an opportunity. You enter into the service,
It is their
not
appointment.
in the process in the procedure, following the procedure by law.
It is their appointment, and they have not replied on this.
And this appointment is an appointment done for 3 months.
3 months later on, it was extended, Lordship.
Is any appointment done for 3 months?
It was extended in time.
Extension we have seen.
Yes.
Show us an appointment, valid appointment for 3 months. Appointment of this nature.
This is for 3 months. Later on, it was extended in time to time. And
Rate for services are necessary for 3 months. Appointment is for 3 months ago.
And by annexure B, Lordship, it was still regulation. It was extended.
Madam, you're not answering.
Yes,
We are not on the extension part.
Yes, sir.
Can there be an appointment of 3 months? What consideration?
But
These are all illegal appointments.
it is made by the director.
We are only on the case you take instructions. What do you say about the appointment process?
My lord, in our affidavit paragraph 9, there petitioner matter has endorsed to the judicial department for their use for declaration of the start of the case.
So this is by R6. Where is the director? And there is a director affidavit also.
Yes, director.
What have you said?
Director of the there is an excess appointment without any vacancy.
If you have come to a finding, you have taken the judicial department's views, why don't you discontinue the service? You utilize the service, you do not pay. You have to pay the salaries. Regulation part, we may not say anything in favor of the petitioner.
In 2001, Lordship, petitioner approached the Honorable Court, and on the basis of their letter to the principal secretary by the director to the principal secretary for regularization of petitioner service, says that the petition was disposed of, directing them to regularize the service. And after that, a lot of communication has been made by the authorities for regularization.
Yes, what do you say?
Regarding the matter of salary part,
Take instruction on Friday, we'll dispose this of. Heard. MSRDB learned concept for the petition. What is this?
I found not to fill up the post till disposal of this because he is holding the post since 1994. The 2 posts are lying vacant in the school, and he is the only person who is
We cannot just say that your age would be condoned and your experience would be considered. We cannot prevent the authorities from filling up the post in a valid recruitment process. Okay, we'll have it on Friday. Heard MSRDB learned concept for the petition. The matter pertains to regularization of the service of the petition as a grade 4 employee in the name of the school?
Patgoria Higher Secondary School.
In the Padgoria Higher Secondary School, Dhemaji, and also for a direction for payment of salaries, pending salaries. The respondents in the affidavit has however submitted that the entry of the petitioner into the service was not in accordance with law, as there was no valid recruitment process. However, on the aspect of non-payment of salaries, Sri Sharma, you shall training council, secondary education department, please for some time to obtain his job. In the interest of justice, please on Friday. This Friday. Next. File the affidavit. You file. Huh? 19 matter contempt, you are not filing the affidavit. Why? Otherwise, you have filed affidavit over. It's a core affidavit has been filed otherwise. No. Unless the court directs you will not file affidavit. Mr. Das? Let him come then. We'll have it day after tomorrow.
Day after tomorrow, I will not be there. After third.
Thursday.
After third.
It appears that no affidavit has been filed in this case, in this contempt case, pending since the year 2019. This court, by the last order dated 10/5/2023, had directed to file affidavit at least 2 days prior to the next date of listing, that is, i.e., today, 29/5/2023. At this stage, three, as the council submits, that's the Bigogoi. Council would be appearing, who, however, is not readily present as agreed to by the parties based on
Second, your lordship can take it.
2nd of June. Friday.
On your lordship may take it up on people. I'm there. That we can.
Second by reflect. Who is that? Yes, next.
Can you peruse the last order dated 15/5/2020?
Yes, we have seen that.
Here, I'm taking 10 days time, but if I've missed out, also 10 days time may be granted so that I can apply the court.
Last order was very clear, 15/5, H. Aliha,
Yes, Lordship.
will apply instructions.
Lordship, actually, the communication has been handed over.
On the prayer of 3 H. Aliha,
10 days time.
Standing Council, Finance Department. Further 10 days time is granted. How are you appearing as finance as Standing Council? It's a contempt matter.
Lordship, I'm appealing for contempt number 2 and 9.
Will not record you as Standing Council.
Yes, Lordship.
3 H. Aliha, Standing Council appearing for the response numbers
2 and 9, Lordship.
2 and 9. Praise for and is granted further time of 10 days to obtain the instructions in terms of the order dated 15/5/2020.
My lord, what has happened was another same out of the same judgment. This
Please
matter
along
was
with
today,
Oh.
along with contempt number 366 of
what has happened?
Hello?
What has happened in that?
today fixed. But that has not been discussed. So that
Oh.
matter may be come up.
Please along with contempt case number
Contempt case number 366 of 2020.
23.
20.
333
No, my lord,
333
366.
366 2020.
March. Date,
We have said 10 days. Mr. Kaur, what is this?
This is also a matter. My lord, paragraph 23, they have not complied with the order. Against this, my lord, they went on appeal. Then appeal, they withdraw the appeal, or the appeal, and ultimately in the appeal, the order was passed that if you would desire, you can file a review petition. They have not filed a review petition also, and now they are not even complying with the order of the court.
What is the direction?
But direction is that this person, my lord, who is before your lordship, from 2001, he has been before this court and all the proceedings, my lord. Ultimately, my lord, he has been asked to give the payment of the dues, that is, your lordship will find a paragraph. His salary part, your lordship will find. Paragraph 23.
Yes.
Paragraph 23 at page 23. Needless to say that the consequent relief that Mohammed Nusrat Ali would be entitled by virtue of being provincialized from 1/1/2000.
The current salary.
Yes, current basis from the month of November 2020 and the area within a period of 6 months. This order was passed a long back.
Yes, what are you doing? Who's appearing? Same order. Same one. Not same date. Separate orders, nothing to do with that case, but same date. 6 doesn't make it.
2/6.
2/6.
My lord, may I pray both these cases later will come on 6th, Tuesday or Monday, 5th or 6th?
5th. Second October, 5th.
Fifth.
The last both on 5th.
Yes, yes.
Matter relates to provincialization of the service of the petitioner. Petitioner is working as Hindi language teacher in upper primary.
Affidavit filed.
Affidavit not affidavit filed by private examiner.
Yeah, for university. And madam? What is it? Oh, Karbi Anglong. Okay. Affidavit filed by whom? 6 and 7. Your affidavit? 21 matter. You file it, will run some time. Here for 3 and 4. You had read for a week's time last occasion.
They have this time for many times.
Okay, last opportunity. You are Sohe. V Sohe. I'm as V Sohe. Learned counsel appearing for the response number 3 and 4. Prays for and is granted further 2 weeks time. 2 weeks to file the affidavit. List on, will give a date. List on. On 16th of June.
Okay.
Similar issue, also they have not filed a affidavit. 21 matter. Many chances have been given.
Here for whom? Private is department, you have filed affidavit.
Oh, yeah.
Brother? Not filed. Why?
Not it may be given.
21 matter.
Yes, your lordship, the petitioner is suffering into removal from service. Matter relates to provincialization of services between me and phone number 7.
Yes, department Mr. Sharma, both the department, both Sri Sharma, Training Council of the Elementary Education, Secondary Education Department, as well as P. Bharadwaj, Learned Council for the response number 7, pray for and is granted 2 weeks time to file the opinion opposition. List after 2 weeks. Let us take 21 months. Come within 2 weeks. List on list on 16th of June. Contempt.
Contempt case, my lord.
Yes.
Ultimately, there is the last order. 12/5.
Instructions.
We have to comply.
Compliance. Has been complied with. Your name is Ponibora.
Yes, ma'am.
Wendy. What is your grievance?
So my grievance is that, my lord, so, my lord, I was appointed as the
No. In the present petition, what was the direction on
Yes,
2/9/2019?
yes, ma'am. Lordship may come to page 18, my lord. The earlier requisition for the other petition, my lord, in the basis of that, my lord, last order was passed. But you may come to page 18, my lord, para 8, my lord.
Yes.
Second line, therefore the respondent are now directed to release the regular pay scale.
Then paragraph 18.
8, my
Consequently.
Yes, ma'am.
Yes.
Consequently,
Okay.
therefore the respondents are now directed to release the regular pay scale for the petitioner as the graduate teacher high school, who is effect from date of their joining, ma'am. The date of their joining, ma'am. The same is shall be done within a period of 4 months from the date of the receipt certificate of the order. Now, lordship, come to the next order, my lord, which was my requisition, my lord. Present requisition, my lord, which was not been complied, my lord. Lordship, come to page 22, my lord. Page 22, para
Yes.
4, my lord.
Yes.
This court in view that if the petitioner is similar situated person as the petitioner is only number so and so, there is a no reason why the petitioner should not be deprived from the similar benefit of the grant of PSCL, more so after the different bench is so and so. According to the petition, this court directed the respondent authority to consider the case of the petitioner directed above within a period of 4 months. And my lord, I have to pay, my lord, from the date of the joining as the regular scale of payment. The time has not been paid to me. Even, my lord, the order is submitted.
Madam, there is no scope for you to take any other decision. This consideration doesn't mean that you will re-examine the case. This has already been decided by the earlier order of the court in 7/6/2013. This has been followed. It has been clarified in paragraph 4. You cannot take any other view.
I think it's correct.
What is WH 233 of 17?
My lord.
What is writ appeal 233 of 17?
So that was dismissed, ma'am. They challenged, my lord. They must.
In paragraph page 22, the reference to the division bench is pertaining to WA 233. Hassan,
Yes, my lord.
page 22.
Yes, ma'am.
The reference to the division bench,
Read appeal, my lord.
writ appeal, is
Writ
it 233?
Yes, ma'am. So that is good. Dismissed, ma'am. They,
Understood, but what is the writ appeal? Is it 233? Reference is to 233. There is no now. Nothing has been mentioned here. That is why I was asking.
my lord, they prefer against this order, my lord. They prefer a read appeal, my lord. They must.
You have understood that the division bench matter, which was the appeal, is number 233 or what?
There is written as 763, my lord. Maybe
763 is the repetition
Yes, ma'am.
number. This is the writ. We are not on the repetition. We are the writ appeal. Madam, 233 is the writ appeal.
Yes.
Same writ appeal mentioned here.
Yes, sir. Read appeal is 233/2017.
Yes.
I'm sorry.
If writ appeal has upheld the decision in 763,
Yes, ma'am.
then you cannot pass this order. There is no scope to pass this order. The findings of this court has attained finality. Writ appeal has been dismissed. How can you take any other action?
An SFP was filed. So
Mere filing of SLP will not do unless there is a stay order.
sometime
But you will be in a difficult position, madam. We are telling you. This is passed on a wrong advice. And this is not a case where we we dismiss this contempt and ask them to challenge this. This is directly in violation of the court's order. The court has already decided the matter. You cannot re-examine this matter again. It's not a question of that the matter was remanded to you for re-examination. Matter was decided. Third, your KM Hassan.
Yes.
Your KM Hassan, learned counsel for the petition. Sarah, MSN Fukan, learned counsel, appearing for the respondent, has, however, placed before this court an order dated 26/5/2023, passed by the Secretary to the Government of Assam, Department of School Education. It appears from a reading of the state order, it appears that the action of the authorities in not granting the benefit of regular time scale of pay to the petitioner has been sought to be justified. The order also states that the earlier direction of this court in WA 233/2017, dated 14/6/2019, was taken into consideration. This court, however, is of the opinion that the matter was adjudicated by this court, and such adjudication was also upheld by the Honorable Division Bench in WA 233 of 2017. Under the aforesaid facts and circumstances, there, in the opinion of this court, there is no further scope of the authorities to re-examine the matter, which would which would be in direct contravention and disobedience of the issue already resolved by this court. Para, at this stage, I have spoken to Learned Counsel Press for some time to obtain further instruction. Para, list on Monday next. You have a copy of this? A copy of the order dated 26/5/2023 is kept with the record. Then for press, it will have to give it. Mr. Chaudhary is sitting for long. Some other day. Which matter? Nowadays, you're not supposed to be in here. You're supposed to be sitting somewhere else.
The responsibility of my client.
Client's responsibility is secondary. Bar's responsibility is much more.
I agree.
Yes, Mr. Sekia, what do you say? Client can wait, bar cannot wait. I don't think he has also performed his duties, immediate duties after winning. Whenever any matter where interim order is still today.
No, there is no interim order. I took out 58. I wanted some accommodation.
Whenever you say, he'll give the date.
I think it's 3 months. This is going to be this case for the contempt case.
Come for motion day after tomorrow. 52 motion for it. Huh? 53, it has been, this court has been informed. The though this matter has been listed for orders, notice is yet to be issued. List for motion on
Item number
66 days.
yeah, new matter lodging the contempt.
Okay.
Let the issue notice for
No, Wednesday. Same order.
new matter lodging.
New matter. He also has a new matter on Wednesday. We'll consider
Motion is
motion only. Wednesday. Motion.
allowed.
To may come up next week.
He'll give the date.